I'll start the meeting. Which PowerPoint?
Davins, yes.
That one.
All right, I'll go ahead and start. So the meeting, call to order the study session for the Planning Commission of the City of San Clemente. It is Wednesday, August the 6th at 5:03 or 4 p.m. And this is a regular meeting of the Planning Commission for a study session. All commissioners are present with the exception of Commissioner McCacken and Commissioner Camp. They are absent at this time. So we are fortunate to have a nice presentation on the California Environmental Quality Act. Would you like to go ahead and introduce yourself and then take it away?
Sure, thank you.
Thank you for being here.
Thank you for having me. I'm Davin Widrow with the firm of Burke, Williams & Sorensen. I'm a partner with Jenna, your Deputy City Attorney, and with Elizabeth Mitchell, your City Attorney. I'm here to present on CEQA, the California Environmental Quality Act, and some important amendments that were made in June 2025. I want to say before we start that I'm going to throw a ton of information at you, and we don't have a lot of time. So I might move through some of it quickly. I'm always happy to come back and delve in depth. But I'm presuming that you have some familiarity, but not a whole lot of knowledge of CEQA. Some knowledge of CEQA is necessary to understand the changes that were made in June. So with that, let's get started. Here's our agenda. We'll go over the basics of CEQA, CEQA process and requirements, what CEQA litigation and judicial review looks like, and then the recent CEQA updates, and if there's time, I hope we'll have questions and discussion. Let's begin with the CEQA overview. So the objectives of CEQA are to inform decision makers and the public about environmental impacts of proposed projects, to identify ways to reduce or avoid the impacts of those projects, environmental impacts of those projects, to prevent them by requiring alternatives or mitigation measures, and to disclose the reasoning for approving projects with potential environmental impacts. What's important to note there is that one of the objectives of CEQA is not to choose the best environmentally policy-wise alternative. The main objectives of CEQA are to disclose and to be transparent and to identify. So CEQA is made up of two main legal frameworks. There's a STICHWA statute at the Public Resources Code, which is enacted by the legislature. And there's the CEQA guidelines that further elaborate and provide details to the statutory code. These are at the regs. They're adopted by the California Natural Resources Agency. And the guidelines are given a lot of deference by the court system as well, as almost as equal as the statutes. All right, so we'll move right to CEQA process and requirements. So there are typically, folks describe 3 stages of CEQA analysis. Stage 1 is the activity a project subject to CEQA. Stage 2, if it's a project, is it exempt from CEQA? Stage 3, if it's a project and if it's not exempt, could it have a significant effect on the environment? If so, if the answer to number 3 is yes, you prepare an environmental impact report or an EIR. So let's do stage 1. A project is an activity undertaken or funded by a public agency that has the potential to result in direct or indirect physical changes in the environment and requires discretionary approval by the agency. There's some statutes there because I'm a lawyer and I'm required to provide you with statutes. Continuing, what is a discretionary action? What is a ministerial action? A discretionary action requires the decision maker, that could be you, to exercise judgment about whether to approve a project and whether changes should be made or conditions should be applied to the project. In contrast, a ministerial action, you have no discretion. If a project application conforms to applicable statutes, ordinances, standards, and the agency is not allowed to exercise subjective judgment about whether to approve the project or how the project is carried out, that is a ministerial decision. Ministerial decisions are not projects under CEQA. They do not undergo CEQA analysis. Courts will typically ask, does the agency have the power to shape the project in ways that are responsive to environmental concerns? If the agency can modify or reject the project for environmental reasons, it's likely discretionary, but if not, it's likely ministerial. There's a lot of case law and a lot of examples. Typically, if a project is showing up to you, big developments, public works developments, residential mixed-use developments, most of the time those will be discretionary. A ministerial project is generally something like a building permit application, although not always, I want to stress. So, if it is a project, we move to stage 2. Is it exempt from CEQA? So there's 3 different kinds of exemptions. There's statutory exemptions. These are enacted by the legislature. They're absolute, and these are for projects that even if they will cause significant environmental impacts, are still exempt for public policy reasons because the legislature has said so. There's over 40 of these. Compared to that is categorical exemptions. These are contained within the CEQA guidelines, and these are promulgated by state agencies. These are for categories of projects that generally do not have significant effects on the environment, and so it's not worth doing an in-depth environmental analysis of them. And then finally, there's the common sense exemption. This is a catch-all. This is for when it can determine with certainty, as it says, that a project will not have a significant impact on the environment. I'll give you some examples of all 3. So common statutory exemptions, ministerial projects like building permits when they're discretionary, utility connections, rezoning projects consistent with community plans. Emergency projects is a big one that we see, repairs, preventative action, especially ahead of storm season or wildfire season. Mass transit project, minor infrastructure project, rooftop solar projects, and farm work or affordable housing and infill projects, which we'll get to later. Common categorical exemptions, class 1, we call these classes. This is existing facilities of structure. You can make changes or modify them as long as there's a negligible and no expansion of existing uses. Same thing, reconstruction and recomplacement of existing structures. It must be on the same site, the same purpose, generally the same capacity. Small projects like single-family homes, restaurants, carports, certain regulatory actions to protect natural resources and the environment. State agencies use this a lot, but this exemption was litigated extensively over plastic bag bans that cities had adopted. Accessory structures like lifeguard towers, portable restrooms, and certain infill developments, again, we'll get to later. There's a lot of categories that go into whether something is infill. It has to be in an urban environment. It can't have certain impacts. But if it's infill under the statute, it will be exempt. So there's unusual circumstances, significant effects is the minor footnote there that can override certain exemptions. Basically, if there's unusual circumstances or significant effects that are unforeseen with a regular type of project this way, you may have to show that there's still no significant impact of the like described. Then finally, the common sense exemption, it specifically provides if it can be seen with certainty that there's no possibility that the activity may have a significant effect on the environment. Also heavily litigated, but common ones would be an interior home renovation, statue removals, we saw some of those a few years ago, and revegetation plans maybe after public works projects or after fire incidents and other such things. I'm sorry? The common sense exemption is heavily litigated. For example, folks, there was a lot of litigation, not for interior home renovations, for cannabis use stores is primarily one. Sure. So it's not exempt from the environment. It is a project and it's not exempt from the environment, so you move to stage 3. Could the project have a significant effect on the environment? Those are a lot of technical terms. I'm going to try and run through this with you a little bit, but the first part of that analysis is an initial study. Some of the staff behind you will probably do parts or contract out to do the initial study. That's a checklist that the CEQA guidelines provide to help you go through to determine at a preliminary level if the project's likely to have a significant effect on the environment. Included in the initial study is a description of the project and the location, the environmental setting regionally, and the baseline. So that's the environmental conditions existing at the time the project is submitted for approval, or at least the project is submitted for public review. And what it generally does is it compares the baseline as the environment exists now, and it compares the environment as it exists after the project has been built, and determines whether there's any potentially significant impacts in that delta. And there's 20 different impact categories that the initial study considers. Here's an example of what an initial study checklist looks like. The ones that are cross-marked are because there's been recent updates to them. They're not especially special, but they have had some recent updates. But this is what the checklist typically looks like. So you've done your initial study, and you find that you're going to come out with 3 different possibilities. If you have no significant effects, you can move forward with a negative declaration. If you have significant effects, but they can be reduced with mitigation, you can prepare a mitigated negative declaration. And if you have significant effects, but they're not easily mitigated, you're likely going to have to prepare an environmental impact report. So let's look at all of those 3 very briefly. A neg dec, we say in parlance, it shows that the project will have no significant environmental impacts. It describes the reasons. It's a document that the project will not have a significant impact and therefore does not require further environmental review, such as in an EIR. The agency must give notice and provide public review period. There's big thumbs up in the background there because neg decs are quick and they're easy and they don't cost a lot, but they come with a big price tag otherwise, as we'll see in just a sec. A mitigated negative declaration is a neg dec, but there's some elements to the project that may cause a significant impact on the environment, but those impacts can be easily remedied with changes or modifications to the project as proposed. Those proposals have to be incorporated into the project before approval, and the mitigated negative declaration also has to be released for public review and comment. Finally, an environmental impact report is required when substantial evidence of the record supports a fair argument, and those words are highlighted, that a project may have a significant impact on the environment. The fair argument standard of review is a low threshold to challenge. So, an EIR may only be avoided if the project is exempt from CEQA or if there's no substantial evidence that the project may have a significant effect on the environment. So, neg decs and mitigated neg decs are great because they're quick and they're easy and they're inexpensive. They're risky because the fair argument standard means that even if the project may have a significant impact, you don't have to prove that it will, then you're likely to have to go to EIR land, and the decision to prepare a neg dec or an MND could be reversed by a court. So what's the purpose? If you're in EIR land, what's the purpose of an EIR? To inform the agency and public about environmental effects of the project, to describe ways to minimize those impacts, and to identify alternatives to the project that may reduce impacts. There's a lot of requirements for EIR. There's a lot of small text there, text, but basically you're supposed to describe the project. The description of the project must be finite, accurate, and stable. So you can't have a project that changes over time. Something that comes to mind is maybe a freight line, where the line runs here in one version of the project, but it lies 15 miles away in another version of the project. Or it ends somewhere and it begins somewhere. That's kind of what we're talking about. It has to be a firm project description so people know what they're looking at. The environmental setting, as we discussed earlier, establishes the baseline at the time the application is made, and the environmental conditions in the property. CEQA presumes that we're not waking up on the first day of creation when the project is built and the environment is not pristine. So part of the purpose of the EIR is to set the baseline for the environmental analysis that should be for the baseline for the delta that the project will cause in the existing environment. Part of that setting is to describe the environmental effects that the project will have. These are physical impacts, not social or economic impacts. It has to be a direct or reasonably foreseeable indirect physical impact on the environment. Finally, the last 2, mitigation measures, are measures in the existing project that will reduce the impact. Sometimes these are committing to different kinds of construction measures, different kinds of fleets if it's a distribution center, incorporating air filters or other mitigation measures if they're residential facilities near industrial facilities. Those are some examples. Alternatives are alternatives to the project itself. You have to include a no project alternative under CEQA. We also see a lot of reduced footprint alternatives or reduced size alternatives are a lot of what we see. What is a significant impact on the environment? It's a substantial or potentially substantial adverse change. CEQA Guidelines Appendix C provides sample standards. A project may have a significant impact if there's a reasonable probability that it will result in a significant impact. That's a lot of legal speak, but basically we're talking about something that's significant and substantial, not something that's minor. Otherwise, it would fit presumably into a categorical exemption. So a lot of stuff here. So what is a feasible mitigation measure? It has to be something that you can do. It has to be something that is implementable. It has to be something that's cost affordable and something that will result in meaningful impacts. If the court finds, if the agency finds that all mitigation measures have been adopted and all alternatives have been adopted that would reduce the project that are feasible, and there are still significant effects, then either you or the City Council will adopt a statement of overriding considerations that explains why the project is important to adopt from a public policy perspective, even if there are remaining significant environmental effects from the project. Courts will defer to your judgment as long as there's substantial evidence in the administrative record to support it. Okay, lots of popcorn. How much is too much in an EIR? EIRs are typically thousands and thousands of pages long if you include the appendices. So CEQA says it promotes informed decision-making. Analysis is based again on what is reasonably foreseeable, not pie-in-the-sky alternatives. It must be adequate and complete, but you don't have to analyze every single alternative and infinitum. And conclusions must be based on factual evidence, not on assertions. So there are outer bounds. Whether they are obeyed is a matter of editorial policy. Typically, the litigation landscape around CEQA means that agencies will produce longer reports than is probably necessary. So I'm not going to throw a lot of text at you, but basically here's the overview. So we do an initial study, that's the scoping. They send it out for the public with a notice of preparation inviting comments. That will usually be, following that will be a draft EIR that goes over all the stuff that should be discussed, like we discussed in the EIR, the setting, the baseline, the mitigation measures, and any alternatives. And public comments will come in on the draft EIR. A final EIR will incorporate all those comments and any changes to the draft EIR, as well as any significant new information. Then both of those will come to the decision maker, that'll be you or the City Council, for certification, which is one thing, of the EIR or the other CEQA document, and project approval. Again, a lot of text, but that's the legal standard. If the project is approved, the agency should file a notice of declaration. Doesn't always happen, but a notice of declaration is helpful because it serves to impose a shorter statute of limitations for challenges to the EIR. So if you file notice of determination, you've typically got, for an NOD, 30 to 35 days. An NOE, your staff can probably know better than I do, better when it's a 30 or 35 days. If it's not, then it's going to be 180 days. So challengers will have a lot more time if an NOD is not filed. Subsequent CEQA review. CEQA presumes that once you've analyzed once, you're done. So there are only 3 circumstances where you will reopen environmental review for a subsequent project. That's if there's substantial changes to the initial project, if there are changes in circumstances that were not addressed in the initial EIR, or there's new information that becomes available that was not included in the old EIR. So what does this typically look like? Maybe there's a master plan EIR that allows developments in certain areas. Typically, you can use that prior EIR to approve subdevelopments within that master plan. You will only have to do subsequent new SEQA review if there's substantial changes to that EIR, changes in circumstances or new information that wasn't available at the time. And the form of that substantive review will change. So if there's a lot of new impacts or a lot of new information, you're probably going to have to do a subsequent EIR or a supplemental EIR. A subsequent is a full EIR, a supplemental is just portions. Or if you're lucky, you can do an addendum, which is just minor or technical changes to the old EIR. Addendum does not require the same kind of public comment and review as a subsequent or supplemental EIR. Okay, so we're going to get to the fun stuff, knives out. CEQA litigation and judicial review, because it's part of CEQA. Why do people do it? Petitioners will do it because they want to oppose bad projects, because they want additional mitigation measures incorporated, or they prefer the alternatives that they envisioned or that the agency envisioned but did not adopt. Why do people defend? Why do agencies defend projects or project proponents? Because they're good projects, because you need them and because you want them. Because the purpose of CEQA is to promote finality, because you did your environmental review, and once you've done your environmental review, it's done. You're finished. You're not supposed to do exhaustive environmental review of every single thing that could potentially happen because of the project. And finally, one of the main goals of CEQA is to reinforce and maintain agency discretion. So courts will defer to agencies if there's enough evidence to back up the reasoning for their approval or disapproval of a project. So here's the basics. It's a petition. Like we said, so statute of limitations, 30 days after a notice of determination if you did an EIR, 35 days after a notice of exemption, 180 days if you didn't. So it's best practices to file notice of determination or notice of exemption. Your standing requirements for someone to challenge are very loose. So you must have a beneficial interest, whatever that means, or a geographical nexus to the project. The geographical scope of a project can be very broad. If it's a distribution facility that sends trucks hundreds of miles away, then the scope of the project could potentially be the entire freeway corridor that those trucks travel. So very broad standing requirements, but they have to exhaust their administrative remedies. So if the decision is going to the city council or to you, they must come here first and lodge their complaint, or they must file a letter that outlines the specific issues that they have with the project within the time period specified. If they don't do that, you do not have standing to challenge the decision in court. This does not apply, obviously, if the agency did not provide notice or did not provide a hearing. Never happens here. So courts will apply 3 different standards of review. Courts are limited by separation of powers principles in how much power they have to reverse agency decisions. So we're going to go in orders of stringency here. They engage in de novo review if what's at issue is just purely legal. Did the agency follow the law? Is it a matter of interpreting the law and seeing if the agency followed it? Fair argument, like we discussed earlier, that's if the agency did not prepare an EIR. The question the court has to ask is there a fair argument that the project, as proposed, may cause an impact in the environment? And then finally, substantial evidence, if you did prepare an EIR, court is very constrained. So it doesn't have to like the decision, doesn't have to think it's the best decision. It can think it's poor policy. If there's substantial evidence to support the agency's decision, then the court has to uphold it, even if there's evidence on the other side. So it's always worthwhile to include a lot of evidence in the agency's CEQA documents, no matter what they are, because courts are required to give those projects a lot of deference. Always 2 questions. Is there substantial evidence, that's the key term, to support the agency's decision? Did the agency fail to proceed in the manner required by law? 1 is a very technical question. Number 2, the first one is a very fact-intensive, heavily litigated question. Okay, I can go through all that. I don't want to waste too much time on it, but substantial evidence is facts, reasonable assumptions, expert opinion. It's not argument, it's not speculation, it's not unsubstantiated narrative, and it's not erroneous, inaccurate facts, and it's not social or economic impacts that are not caused by physical impacts to the environment. Little nuance right there. The administrative record is what's going to contain all of this. So when the court looks at it, there's no discovery. There's just a closed administrative record. What was before the decision maker when they made their decision? That's usually closed. The scope of that is sometimes fought over, but it's generally a good idea to make sure that you get all your substantial evidence in the administrative record as early and as soon as possible, because extra record documents are generally not admissible in CEQA. Did the agency proceed in the manner required by law? Really much more procedural thing. Did you have the hearings? Did you have hearings? Did you respond to comments? Did you do things within the timeframes required? This can be used sometimes if the agency omits information that is critical to understanding the project. And that's not quite procedural. So if there is something, we have seen cases, not here, but there's case law out there where courts have reversed decisions based on this ground because a critical piece of information that would inform the public and the decision maker about the project was not included in the document. So important to include all sorts of information in the project, which is why you land up with 5,000-page EIRs. All right, now we're coming to the meat of our discussion. So having presented all that, there were some recent updates in the state budget to CEQA that were passed, and we're going to go through a bunch of those. Any questions? Before I do that, any questions on CEQA? All right. So, we're talking about two bills that the governor signed here, AB 130 and SB, yes?
I do have a question, actually, sorry.
Sure.
Do projects still have to do a level of service traffic analysis, or is it all vehicle miles traveled?
It's vehicle miles traveled now is the statutory requirement for traffic impacts. There's two places where this doesn't necessarily apply. So if you are using a prior EIR from before the time that VMT was the required analysis, when they still used LOS to determine traffic impacts, then there's no sense in using VMT in your new analysis to compare it to LOS. It's apples and oranges.
Sure.
So this law will let you use an LOS. Usually the agency also does a VMT just to protect itself in that situation. You can also use LOS, but not for traffic impacts. So if you want to look at, say, are there going to be impacts to infrastructure, or what's going to be the air quality impacts of a lot of cars or trucks concentrated in one place, then you could use LOS analysis to determine the scope of that impact.
But when you say you can do that analysis, as part of CEQA, or as just part of like the agency conditioning the project to do mitigation?
I do not believe that you could condition the project in mitigation based on level of service if it was related to traffic impacts. Because the law requires you to use VMT and not LOS for traffic impacts. So whether you analyze it or you apply a mitigation measure, I don't think that the mode of analysis to apply that could not be LOS if it was for traffic impacts.
So I guess I don't understand your first answer then. I understand if there was an old EIR with LOS, then to go back to LOS.
Yes.
But on a new project, VMT is required. Why would they do any LOS analysis?
They would do it, so say, you wouldn't do it for traffic impacts, you would do it for something else.
For like greenhouse gases or something?
Correct, exactly. So you want to look at a localized spot where maybe there's going to be an LOS E or F, and there's likely going to be monoxide impacts or greenhouse gas impacts.
Got it. And is it basically the case now with VMT analysis that if your project is not within a half mile of a high quality transit stop, that basically you have to do an EIR, or?
There are exemptions for certain projects within certain distances, and again, your staff may be more familiar with that exemption, but within transit, yes, within transit, it's like TO, transit-oriented districts, or transit-serving facilities. Yes, there are certain exemptions for those.
No, right, I understand
Yes.
that. But I'm saying if you're outside that bubble, of which I understood to be half mile, then you pretty much had to do an EIR because you're going to generate more vehicle miles traveled and you're not close to a transit stop.
It depends on the level of significance that's being applied. So not simply generating a certain amount of VMT Like, so Appendix G, which lays out those 20 subject areas,
Okay.
also includes traffic impacts. And so there will be a certain threshold, there's thresholds that agencies through, here it would be like the South Coast Air Quality Management District, will determine how much VMT generation will equate to traffic impacts or a transportation study or something like that. And if it exceeds that certain threshold, then there'll be a significant impact. But if it's below that impact, then arguably you don't have to do an EIR. So it
Okay.
depends on whether your analysis finds that it will exceed thresholds for significance. So again, it's not just any impact. So it has to be a significant impact on the environment.
Right. Okay, thank you.
So it would have to be a significant VMP impact. I'll also just say, sorry, in closing that conversation, that although you could theoretically use LOS to measure air quality or GHG, I haven't seen that very often. There are other ways to do it besides using LOS, which has become a bit of a thorn bush lately. And let me know if you have any follow-up questions. I can look at those. All right, the amendments. So, two bills, AB 130 and SB 131. AB 130 adopted a statutory infill housing exemption. There was already a categorical one, but this is a statutory one. It also adopted a VMT, so we're getting to VMT now, Impact Mitigation Fund, and it also adopted certain non-CEQA housing amendments. SB 131 adopted new categorical exemptions. It adopted a new exemption process for what they are calling near-miss projects, and there's certain not so minor litigation reform in terms of what's required in the administrative record. So I'll go through those each. So let's start with the first thing, the statutory infill housing exemption. This applies to housing development projects. These are projects that are less than 20 acres. They're either residential projects or they're mixed-use projects that have 75% residential units. If it's a builder's remedy project, it can be 5 acres or less. The project has to be within an incorporated municipality or an urban area. So, and there's a lot of definitions for what a prior urban use is. If it's not in an urban area, it has to be if substantially involved with urban uses. So either it involved a previous urban use, 75% of the perimeter was urban use, 75% of a quarter-mile radius was urban uses, or if it's a 4-sided parcel we're dealing with, then 3 or 4 sides are urban uses and 2/3 of the perimeter are urban uses. So there's a lot of work for consultants to be done and your city staff in trying to figure out if that's the case. But generally, within your jurisdiction, it's going to most likely be urban uses. There's a lot of text there too, but it comes with strings. So the project has to be consistent with the general plan, zoning code, the local coastal program, and density standards. It has to be at least 50% of the Mullen standards, which require 10 to 30 units per acre. It cannot be located on environmentally sensitive lands, hazardous waste sites, prime farmland, earthquake fault zones, floodways, or very high hazard severity zones. There are definitions for all of these. You're not allowed to demolish historic structures listed on a historic register, at least not prior to submitting the application. Interesting text in the reg there. No hotels, motels, or beds and breakfast. It has to be residential. Projects within 500 feet of a freeway must have air quality mitigation. So enhanced air filtration systems, and typically it includes orienting balconies and living room windows and such away from the freeway. If this is a site that's had prior hazardous waste or still contains hazardous waste, the agency or the project proponent will have to do an environmental site assessment and perform a remediation and mitigation before a certificate of occupancy can be issued. So lots of requirements for the statutory infill housing exemption. So acreage exemptions, density exemptions, urban use requirements, and then don't put it in certain places requirements. More requirements. So there's tribal notification requirements. I won't go through all of these, but basically there's a clock that runs on all of this. So if the agency finds the application complete, 2 weeks to notify all affected tribes. Tribes have 60 days to accept the invitation. Consultation is mandatory. You don't have to agree, but you have to try and find measures that would avoid significant impacts to tribal cultural resources, Tribal cultural resources can be artifacts, burial remains, cemeteries. It can also be places of significance, so not necessarily physical artifacts. Consultation must conclude within 45 days, which is a good thing, although you can have an extension. What must come out of them are enforceable mitigation agreements. This is often already included in most EIRs and documents that do find impacts to tribal cultural resources. It includes tribal monitoring, ground disturbing and construction activities, work stoppages, and typically there will be fees required for tribal monitors. Finally, new labor requirements if you want to use the exemption. So if you want to use the exemption, your construction, to qualify for your exemption, projects constructing over 85 feet in height or which are constructing 100% affordable housing must pay prevailing wages and employ skilled and trained certified workforces. The project proponent will be liable if contractors fail to comply with these requirements, and there is now a state committee or a joint labor management committee that will enforce these certain requirements. So not all projects, but projects over 85 feet in height and 100% affordable housing developments. Some requirements to the City or County of San Francisco that don't apply here. VMT Mitigation Fund. Okay, so we're done with the infill exemption. AB 130 also adopted an impact mitigation fund. So like we said, transportation and traffic impacts are analyzed under CEQA using VMT. So what is VMT? It's the vehicle miles traveled that we generated by traffic serving or accessing the project. So you build a project, how much traffic will it generate to and from the project? VMT replaces level of service. Level of service typically analyzes how long are you waiting at traffic lights? Are people backing up? Is there a lot of delay being caused? If you are finding significant VMT impacts, there will be a fee system that you could pay into that the state is setting up. So similar to affordable housing requirements, it's kind of like a VMT mitigation fund. Or like sometimes you will take certain parcels of land and you pay into a mitigation bank. This will be the same thing. It's supposed to be active by July of 2027. Finally, 3 major non-CEQA housing.
Can I follow up on
Yes.
the VMT?
Yes.
So does that mean that if you, let's say there's a project and it is going to, generate VMT and it's not exempt because it's close to a transit stop, that you can avoid an EIR by paying into the mitigation fund?
Yes, but you would have to show that the payment would result in the actual mitigation to the project. So presumably if the state was setting, so this usually happens with like greenhouse gas credits. So a project proponent could pay credits to offset greenhouse gas emissions. Those are okay as long as they're certified and certified as actually mitigating greenhouse gas somewhere. So as long as the VMT is going to be actually resulting in mitigation, then yes.
But how could you, if we're just paying dollars into a fund, how can anybody certify what that fund is going to do with that they're going to do the mitigation?
The way it works with CARB is CARB will find projects that are actively reducing greenhouse gases and without any projects. So there's a net benefit. And you can pay to have portions of that to offset your impacts.
Okay.
It will be the same thing with VMT. So I think they'll find projects where there's a net VMT benefit. Maybe there's a reduction in VMT.
Okay,
And you pay into that.
Thank you.
Sure. Again, I'm not actually, the state's in charge, so I'm speculating, but I think that's what it would look like. Finally, 3 major non-CEQA housing updates. So shot clock. If you get a ministerial application for a housing development project, again, you're somewhat unlikely to see this because it's ministerial. So if you get it, you have no room for discretion. You have to just apply standards. If it meets the standards, you have to approve it. If it does not, you have to deny it. You have to approve it within 60 days after the application is deemed complete. If no action is taken, the project's deemed approved. So the state's trying to push housing development projects, and if the agencies don't act quickly enough, they're going to be deemed approved. The Coastal Commission is getting some fires lit underneath them. They used to have longer project review deadlines and timelines than other agencies. They now have the same timelines as other regulatory agencies. The bill also prohibits appeal of many residential projects to the Coastal Commission. And I know that's important. So the only ones that I could find exempt were projects between, the ones that will have to be appealed, are projects between the sea and the first public road parallel to the sea, or within 300 feet of the inland extent of the beach or the mean high tide line, or projects located on tide lines, submerged lands, public trust lands, within 100 feet of a westland estuary stream, or within 100 feet of the seaward side of a coastal bluff. So you may be running out of space for non-appeals applying all of that, but if you can find your way through that, you do not have Coastal Commission appeal for your residential project. And finally, agencies may not add or appeal or amend their the state residential building code standards, including green building code standards for residential units from October 25 to June 2031, unless it's related to public health and safety, emergency fire safety, or conservation. I guess that they are presuming that agencies are trying to find ways around housing by adopting maybe stricter housing codes. Okay, SB 131. SB 131 is great. It throws a big menu at you. So, a lot of new categorical exemptions. So, rezoning projects to implement an approved or certified housing element. The state's coming down on every agency about this. You do not have to do CEQA on a rezoning project to implement an approved housing element. Agriculture and farm worker housing projects, daycare, rural health centers, nonprofit food banks and pantries, people who help people. Advanced manufacturing facilities is an interesting one. Clearly the state wants to promote light industry, semiconductors, nanotechnology, that kind of stuff. Water system and sewer infrastructure projects, but usually these are for, and there's a lot of technical terms in water system law, but it's basically disadvantaged communities with failing systems. Wildfire risk reduction projects, this could really apply here, such as prescribed burns, fuel breaks, defensible space, broadband infrastructure. Public parks and non-motorized trails is a big one. I want to highlight that it's funded in whole or in part by Prop 4 of 2024. So you would have to do some sort of accounting to see that the project you're working on had some or portion of funding from 2024 Prop 4 funds. And then high-speed rail facilities, which includes rail facilities, but also passenger station upgrades to incorporate high-speed rail. Near-miss projects. This is a good one. So, I mean, they're all good, but this is one that's neat. So, for projects that meet all but one factor of an exemption, all but one factor of an exemption. So, a near miss, you get a streamlined environmental review. We used to call this like a focused EIR, something like that, but it's now kind of formalized. But you need only do environmental review of that one disqualifying environmental effect. You do not need a 5,000-page EIR for one particular impact that's being caused that takes you out of exemption land. What's also good is that analysis of alternatives. Cumulative and growth-inducing impacts. Cumulative impacts are impacts that happen in conjunction with other projects that are happening concurrently. And growth-inducing impacts are projects that might generate new populations, new amounts of people that would require utilities and services and housing. Don't have to analyze any of those if you have a near-miss project. You don't get to use near-miss if, again, you're on predictable areas, if it's a housing project on protected lands, projects or distribution centers, oil and gas infrastructure. Distribution centers will not get near-miss. Oil and gas infrastructure. Projects similar to those typically eligible will be an interesting thing for courts to consider in the years ahead. But they're going to have to decide what is dissimilar, what is typical.
Devin,
Yes.
what does it mean on the excluded housing projects on natural and protected lands? Is that natural lands or natural and protected lands? What?
It's usually, that's shorthand for, so there are different procedures, but it's the latter.
I mean,
so it could be.
Because most housing projects are on natural land.
Yes, so no, it would have to be protected, it would have to be set aside, or
Okay.
designated, or sensitive for some reason. They're thinking about wetlands, or they're thinking about like open space and parks and things like that, yeah. And then if you only get one near miss. So if you have more than one, you are sent into a different category. All right, big litigation reform, and we deal with this all the time. So you used to have to do a big search. Everyone and staff hates it, but you used to have to search every single email related to the project. Every single email, every single document, every single calendar invite. And if you're safe, you just throw that all in, and the courts hate it, and everyone hates it because it's too much information. So now it excludes staff notes and internal agency communications from the AR. It does limit it to communications that are a logistical nature, such as meeting invitations, scheduling communications. I can tell you there are thousands of these that come into an AR sweep. Internal agency communications, including emails that were not presented to the final decision-making body. That's important because staff needs to be able to deliberate and have discussions with each other without worrying about whether the email that they send will 3 years from now land up in secret litigation administrative record, unless the email was shown to the final decision-making body. Of course, if the final decision-making body or the final decision-making person looked at the document and used it, it has to be included in the AR, but this does definitely limit the scope of what is typically a huge part of administrative record. All right, and 5:48, so we have time for questions and discussion. Exhaustion, caffeine, white flags of surrender.
Well, this looked like your first time doing it, so way to go.
Thank you.
Let me turn to my colleagues and see if there are any questions. We'll start with Brett. Did you have any questions? Okay.
I'm good, thank you.
Sure.
Yeah, I guess it's more of an observation, but on the AB 130, the infill housing exemptions, it seems like when you filter them all, like it's super hard to get that, right?
Yes. I think that there was a lot made in the press about the housing. I mean, there are a lot of important exemptions in both bills, but AB 130 in particular is a bill that was crafted by many stakeholders, and that shows in the text. So yes, you would have to go through a bunch of hoops in order to get through it. You're probably better off going through the categorical infill exemption, frankly, which would require you just to examine whether there's urban uses or impacts to, I think, aquatic resources or air quality, stuff like that.
Okay, thanks.
I just add the main change there too, the existing categorical exemptions 15332 and is limited to 5 acres. So the delta of 5 to 20 is going to be what affects some people. We don't have a whole lot of properties over 5 acres available for development. And similarly, I just wanted to comment as well that there's some provisions of that related to height and labor that were mentioned, but before that, it has to comply with the local zoning and general plan. So the 80-plus foot developments still would not have applicability to San Clemente because it wouldn't meet that criteria of being conformant to our zoning.
Perfect.
Did you have any more, Scott?
No, I'm sorry.
No, it's fine. Karen?
Jonathan just answered the question in my head.
He's so good.
You read my mind?
I think we have a lot of infill projects here,
Yes.
and a lot of them are occurring, I think, on the coattails of a current EIR.
Yes.
Any changes to those procedures?
EIRs never expire.
Okay,
So if you have an EIR that's already been done to analyze a project, you don't need to do new environmental analysis unless, again, changes in the project that were not envisioned within the original EIR or the circumstances. Like maybe the original EIR thought that there would be a residential project and you want to put a mixed-use project there. Or even mixed-use, maybe you want to put a gas station there would be a better example. That would be outside the bounds of what was envisioned there. Or maybe when the EIR was done, there wasn't a you hadn't set aside, maybe there wasn't a park adjacent to the area that was being
that's
analyzed.
pretty specific. I
Yes,
mean,
correct.
We're not really seeing that kind of
Correct.
stuff here.
Typically, it's, is this more intensive use than was analyzed? So
Okay.
is your project going to be more intense than what this old EIR analyzed?
Someone's going to have to make some kind of threshold test.
Yes, correct. Typically, so the original EIR will set, so most often it will be air quality or GHG or traffic impacts.
Yeah.
And so those will all set thresholds. So if it exceeds so much emissions of carbon dioxide or nitrous oxides or PM or greenhouse gas
That was in the
emissions.
EIR previous,
Yes.
right? So basically, it's kind of like, hey, we had this many VMT, so, and we don't expect that to change or exceed that cap, so
Yes.
it's going to get the exemption.
Say you had 40 units of VMT, whatever VMT units is.
Yeah.
And your new project, the development under the EIR up until now has generated 25 units of VMT. And your project will add 10, that brings you to 35. You're still within the impact analysis of the prior EIR.
Do you see changes to the so-called scoped EIRs? I mean, that's the ones that we may get, is somebody's going to have to do a limited scope one. Is that now more expanded, or is that still the case where you can have, I'm only doing, a subset of the package?
You can still do that. I mean, you would have to find that everything else is not a significant impact in your initial study.
Do you have to do that through an empirical study, or can
Do
you
an
do?
initial study, which you would have to do in any event, but the ultimate EIR that you generate could probably spend most of its time, the vast majority of the time, where there's actual impacts. The near-miss exemption may help.
Okay.
So if the only reason that it is because of one impact, then you can probably go into exemption land and ignore the EIR.
Yeah, gotcha.
Or do an EIR, on just that one impact, which would be a much
So
smaller
the near miss
document.
thing, that could be something very busy.
Yes.
That's actually what probably is going to apply to us the most.
That's what I'm hoping, yes.
Yeah.
I'm editorializing again, but yes.
Okay.
Just a couple follow-ups. I'm talking about an EIR that's been in place for 10 years, let's say, but no development's been done. Is it the responsibility of the agency to determine whether there's anything that's changed, that there's significant changes?
Yes.
So that's a process that staff would go through?
Yes, it's a process that staff would go through. If there's a private project involved, then typically the private project proponent will pay for the consulting that is necessary for that. You triggered a question, sorry.
Well, my next and last question is, if impacted constituents around the area have an interest in challenging the EIR, and they bring to the city that we think it's missing this, or there's been substantial changes, who's responsible to make that determination? Yes, you're right, we need to update it, or no, the city doesn't think we need to. Is that us? I mean, the city that makes that decision?
Yes, so what will happen is you'll get a project that's later than that, so we'll use the 10-year EIR. You'll get a later project that kind of fits within that EIR, and the decision maker, you or the city council or Jonathan, will decide that it's either fine, it doesn't need any changes, and you'll just totally tear off, the analysis has been done, or it's minor, you can do an addendum,
Right.
or you do subsequent or supplemental, which will go for public comment. When those go for public comment and then approval of those subsequent EIRs, they will have an opportunity to challenge the EIR, that decision at that time.
Got it.
But the decision will be limited. The court will only be able to look at whether there's new or significant impacts from the prior EIR. Obviously, the thing to bear in mind is the older your EIR is, the more vulnerable it is to challenge. So, you have a 20-year-old EIR is going to use LOS and not VMT. It's not going to have as much GHG analysis. Some of the air quality analysis is going to be a little less. So the older it is, the more vulnerable it is to challenge that it's not up to date.
Thank you.
No, I have one more question.
Got one more, and then we'll wrap it up.
Okay, sure.
So you said EIRs don't have like an expiration date for their approval. Is that also true for mitigated neg decks?
Yes, but it's harder. Yes, it is true. You could tear off an older mitigated neg deck, but again, that would be challenging again because you would have to find no significant impacts from your new project within the scope of the old neg deck, and that or if you were doing a mitigated neg deck, You'd have to show that the mitigation applied in the old project also completely mitigates the impacts from your current project.
Okay,
Yeah.
thank you.
It's the analysis that remains, that doesn't expire. It's not the document.
Thank you for the time you put into preparing all this and practicing and being so thorough. It was
problem.
helpful, and no doubt we'll maybe call on you for your services in the future. So thank
Sounds
you.
good.
Thank you very much.
Thank you very much. Thank you for your
I'm
patience.
going to, do we need to do a motion, or can I just adjourn? Okay. I'm going to adjourn our study session.
Yes, sir.
Everybody's here, okay. Was that?
Except for the doctor.
Yes. All right, we're starting a little late. I'll call to order the regular meeting of the City of San Clemente Planning Commission. It is Wednesday, August the 6th, 2025. We're meeting in the City Council chambers at City Hall. I think we will do the pledge, so I'll go ahead and lead it. If everyone could join me for the pledge. Ready to begin?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, everybody. Yep. As far as roll call goes, we have all commissioners in attendance with the exception of Commissioner McCacken, who has an excused absence. Number 4 on our agenda item is a special order of business, and I, as the chair, am going to take some prerogative to insert a special order tonight. Just for those to understand, we are all serve as appointed members of this commission on staggered 2-year terms. So, and now those appointments get done in June and then are effective July 1. So, and this is our first meeting since our appointment. So we have lost 2 commissioners, and then, which we celebrated and recognized. We knew they were leaving at our June meeting, and then we have picked up 2 new commissioners. So we have Brett Freeman and we have Patrick Giffen. I want to congratulate and welcome both of you to the Planning Commission. Thank you for your willingness to serve. If you don't mind, maybe we'll start with you, Brett, if you just want to just introduce yourself just briefly, and then we'll have you, Patrick, just say a few words about yourself, and then you'll be welcomed. You'll be official.
Well, I wrote something down here.
Oh, excellent. Hey,
I
fantastic.
didn't want to sound like a, anyhow, I just wanted to say thank you. It's an honor to sit up here with you and as the new planning commissioner. I want to thank the city council for entrusting me in this, Rick. That means a lot to me. I also want to thank Cameron for all of your leadership and helping me get up to speed. The staff here is amazing. Jonathan, Tamara, helping us out, getting us on board. It's been amazing. It's clear that the city's guided by thoughtful leadership and dedicated professionals, and I'm proud to join that effort. So I just want to thank you guys, and looking forward to working with all of you. Thanks.
Well, welcome, Brent. Patrick?
Thank you. I echo your sentiments. Really appreciate the opportunity. I know that I kind of got on here a little bit in an awkward way, but I really appreciate the opportunity to serve, and looking forward to working with all of you. And the staff's been great, and you've been great, Cameron, helping Brett and I in particular get ready for our first meeting, so thank you.
Well, welcome. Just want to make sure you guys are part of the team now. All right, that takes us to item 5, which is our minutes. And I will turn to my colleagues to my left who were here last time. Does anyone have any changes to the minutes? We all good? Want to do it?
Yeah, I'll move that we approve the minutes.
Second.
Okay, we have a motion from Commissioner Camp, seconded by Commissioner Prescott Loeffler, to approve the minutes, receive and file them from our Planning Commission regular meeting of June 18, 2025. All those in favor?
Aye.
And you guys are abstained because you were not there. Great. So that passes 4-0. Item 6 is our oral communications, and that's items that are not on the agenda for the audience to address. Any from the audience? Seeing none? Item 7 is our consent calendar. We don't have any. Item 8, which is what we usually spend all our time, which is public hearings. We don't have any of those tonight. So we are at new business. That's item number 9 on our agenda. And is this the order we want to take it in? Item A first? Okay. So this item, as I mentioned, we get new commissioners, and then the very first meeting of a new commission, we reorganize. So tonight, we're going to select our chair, vice chair, and so forth, and our design review. And to lead us in that selection, I'm going to turn it over to staff. So Jonathan, if you take over the meeting?
Sounds good. Thank you, Chair. So the process for nomination and election of the chair and vice chair follows the same process that our council does for mayor and mayor pro tem, which is going to be an open nomination amongst yourselves, so there's no nominations from me or any other member of the public. And once we receive any nominations that are out there, we'll take a roll call vote on those one at a time. So as soon as there's a majority vote for one of those nominations, then we end. So if there's 3 nominations, but the first name that goes through receives a majority vote, that person would be the chair, and then we would move on to nominations for the vice chair. So that's going to be the process. Are there any questions about that before we open for nominations? Hearing none, we'll proceed. And so the time is now to open for nominations.
Well, I would, I'll jump in. I personally think Cameron's done a great job for the last couple of years?
Yeah,
2 years, okay. And seems to have a gift, I think, for the chair position in terms of keeping us on track and
Thanks.
organizing and everything that we need. And so I'd like for him to re-up if you're interested.
Sure.
So I'd like to nominate Cameron to continue.
Does that need a second?
It does not need a second.
I would like
I only
to,
have one, no.
I would like to share in the sentiments there, especially since we have 2 new commissioners joining us. It's nice to have some consistency. So, and Cameron, you've done an excellent job as being
Oh, well,
chair.
thank you, I appreciate it. It's fun to do.
I see no reason to change.
Okay.
Hearing no other nominations, I'm going to go ahead and initiate the vote on Cameron Cosgrove for the chair of the Planning Commission. And if we could just do a vote one at a time, and I'll work from my left to my right. If you could just respond with an aye if you are in support. So that would be Brett Freeman first,
Aye.
Patrick Griffin,
Aye.
Cameron Cosgrove, Steve Camp,
Right.
Scott McCann,
Aye.
Karen Prescott-Leffler.
Aye.
And that's unanimous. So thank you, Cameron, for returning as our chair for the next term. And from here, I'm going to turn it back over to the chair, actually, to conduct the nomination for the vice chair position and to conduct the rest of the meeting.
Thanks, Jonathan. Appreciate you doing that, and thank you for your continued confidence in my role here. Okay, so we have the vice chair, which would essentially just run the meetings if I'm out of town or can't make it. So it's the number 2, it's the person, substitute chair, I guess, but it's the vice chair. So I'll go ahead and open up nominations for vice chair.
I would be
Karen?
pleased to nominate Steve as the vice chair, if he is willing.
Okay, so we have a nomination for Steve Camp for vice chair. Do we have any other nominations? Okay, I'll close nominations. So I'll go ahead and do the same roll call vote. So Commissioner Freeman?
Aye.
Commissioner Griffin?
Yes.
I am an aye. Commissioner Camp?
Aye.
Aye.
Thank you.
I'll just say aye.
Great. Okay. So that's a unanimous congratulations. Thank you, Steve, for being the vice chair. Then, because we have 7 members, we can't, our quorum is 4. So it's possible we could have 3 members absent. So you could have the chair absent, the vice chair, in which case we could still conduct business. So we have a chair pro tem. So I'm going to go ahead and open up nominations for that. Does anyone have an interest in doing that?
I'm happy to.
You want to do it? Okay, so I'll go ahead and nominate Commissioner McCann for that position. Are there any other nominations? I'll close nominations. I'll do the roll call vote for Scott McCann as our Chair Pro Tem. So Commissioner Freeman,
Aye.
and then Commissioner Griffin.
Aye.
I'm an aye as well. Commissioner Camp,
Aye.
Commissioner McCann.
Aye.
And Commissioner Prescott Leffler.
Aye.
It's unanimous. Thank you, Scott, for doing that. Appreciate it. Scott is the Chair Pro Tem. Item B is the selection of our Design Review Subcommittee. That committee also acts as the Cultural Heritage Review Committee as well. And it is 3 members and an alternate. And we meet opposite Wednesdays. So we're meeting the first and third, Design Review second and fourth. And we're primarily a architectural review and making recommendations to the Planning Commission, essentially. So I'm going to go ahead and open up nominations for the design review. We need 3, we'll do 3, and then after we do that, we can do the alternate. Let me just poll the group. Who has an interest in being on design review? And I do as well. So can I just do a group nomination? So I'm going to nominate Commissioner McCann, Commissioner Camp, and myself for the Design Review Subcommittee. Do we have any other nominations? Okay, I'm going to close nominations, and we'll just take a vote on those 3 appointments. So Commissioner Freeman,
Aye.
Griffin?
Aye.
I'm an aye. Camp?
Aye.
Aye. And McCann?
Aye.
And Prescott Loeffler?
Aye.
Do either of you have an interest in being the alternate?
I would like.
You want to be the alternate? Okay. Anyone else want to be the alternate? All right, I'll close nominations,
I
so.
nominate Commissioner Freeman to be the alternate.
Thank you. Okay, you have an official nomination. Commissioner Freeman? Yeah.
Aye.
Griffin?
Aye.
I'm an aye. Camp?
Aye.
Aye.
Scott? Okay, it's unanimous. Congratulations, you're the alternate. So typically you'll hear from Tamara if one of us can't make it. And the procedure's the same as it is. You'll get the agenda online. Yep. And we meet downstairs in the community room, 3 PM on those opposite Wednesdays. Okay. Should we just go ahead and do the chair of the design review, or do we want to do that at the design review meeting?
We'll do that at the design review meeting.
Okay. That was orderly and smooth, so thank you, everybody. Item C on our new business is an interpretation of development standards for planned residential communities, or our shorthand around here is PRDs. I'd like to just set the stage for this a little bit. I've been giving this quite a bit of thought. We had an issue come before us from a community that had an HOH, but they didn't have development standards. As you might recall, there was an applicant that had a home remodel, and their community was split over it, so it ended up coming to us, and then we ended up sending it back. But the core problem here is there's a lack of recorded development standards for older communities in town, and so that creates ambiguity for both the residents and the city staff when a homeowner wants to make additions or alterations to their property. That's the core issue. And so tonight, the staff has brought us a range of options to put in place a policy that they could use for tackling these and processing these situations. And so that's what this item's about. Brandon Hanley, you are the staff person that wrote the staff report that we all got, and you are going to do a presentation too?
Yes.
Fantastic. So let me recognize Brandon to do the staff report.
Good evening, Chair and Commissioners. The Planning Division seeks guidance from the Planning Commission for the review of projects in planned residential districts where tract-specific development standards are not available. This presentation builds on the Planning Commission's discussion earlier this year that highlighted the need for direction on how to review applications so that we can do so in a consistent manner. For some background, on February 19th, the Planning Commission considered an application for additions to residence that was in a PRD. The proposal that was tabled allowed the applicant to work with their HOA and resubmit approved plans. During that discussion, the commission asked staff to return with a policy proposal on how projects in PRDs without clear development standards could be reviewed. This discussion is not directed at any specific developments, just a general interpretation of how communities in this overlay should be treated. Planned residential district zoning was created to allow flexibility, such as clustering homes and preserving open space, by varying from standards in the underlying zone. Newer PRDs can have specific detailed development standards, but older PRDs often do not, creating challenges when residents apply to make these changes. Here are some examples of how that can look. You'll notice on slide 3, I don't have a clicker back here, Tamara, so oh, okay. Let me grab that really, no worries. So on slide 3, here's our second slide, summarizing PRD standards, and then there might be a new file in the folder. Oh, okay. The newer file has another slide that has an example on it. I apologize. I should have let you know that there's an updated file. Just has some pictures in there for you guys. Yeah. There we go. Okay. So this is an example of one PRD. You can see in this image that the homes are clustered together. They're condos and they're touching, basically. They have like shared party walls. And they have a common driveway, and that allows for like shared parking and some open space around them. And then on the next one, these are 3 more that are adjacent to each other. And you can see that they're slightly different. The one on the bottom, the parcels are touching similar to a manner as the last one. And then the one up there on the left, there are no individual parcels. They're all trailers and they're not touching, but it is one contiguous tract. That just kind of highlights the variation between all these PRDs. The city often has insufficient information to evaluate current resident proposals to modify dwellings on site. Staff is in need of direction on how to approach these situations. Zoning and its PRD approval process is permissive. So in that sense, zoning and all that stuff is allowed only if there are clearly established standards and uses. Under a permissive code framework, when standards do not exist, the presumption is that an alteration, like an accessory structure or addition, would not be permitted. Unfortunately, there is no city record of the zoning standard exceptions granted in the approval of older PRDs. All we can work from is the tentative tract map if it's available in any staff reports or minutes from the hearing where it was approved. However, at times there are HOA guidelines to fill these gaps, but many rely on the city to make those determinations. Staff's current approach has been to rely on HOA's approval when available and make case-by-case determinations. If standard guidelines are unavailable, the zoning code has an amendment process to change approved developments. The city planner determines if the proposed changes are insignificant or significant. If insignificant, the city planner is authorized to make decisions on amendments. If significant, a public hearing process is required. The staff position has been to allow changes to older PRDs, again with little to no city documentation, as an administrative amendment. The HOA needs to have clear guidelines for the proposed changes, and staff agrees the project is consistent with the architectural character of the area. If an HOA does not have guidelines, staff has taken a position that the HOA should update its guidelines with staff input in order to make an amendment. Without that, the amendment has been considered significant enough to require a public hearing. The goal of this interpretation is to provide applicants with a clear path to approval of projects in PRD areas without development standards. This should work to form a consistent review process and protect the unique character of planned residential districts. The following are potential interpretations the planning commission can make to clarify how projects and PRDs should be reviewed. Option 1 relies heavily on HOA approval and administrative review. Option 2 retains staff discretion for significant deviations. Option 3 presumes additions were not planned in original entitlements and will not be permitted unless the PRD is amended. Option 4 is similar to option 3, but allows staff approval if the HOA adopts their own standards. These alternatives overlap and are all open for discussion. Staff recommends adopting Resolution PC 25009 with the Commission's preferred interpretation inserted into Section 2 of the resolution. This will clarify how projects and PRDs without standards should be processed, providing predictability for both applicants and staffs. At this point, you guys can discuss what options you think are good ideas and make a decision.
Well, thank you for your presentation, Brandon, and being here tonight. Is this your first Planning Commission meeting?
No, I actually was here when this problem was brought up in February.
Oh, you got to enjoy that night, too.
Yeah, so-
Great, well, welcome back.
Mhm.
Glad to have you. Thanks for your presentation tonight. Before we get into discussion, I think, though, what I'm going to do is just turn to my colleagues. I'm going to go down the line. I'm going to start with Brett. I'm just going to see if they have any questions for you on your report, and then we'll move on. Is that all right?
Of course.
Okay. So just staff questions for the staff. So Brett, do you have any questions?
Before that, can you leave up the slide
Yeah.
with the 4 options?
Mhm.
Can we leave that one up?
Yeah.
Thanks.
Okay. Questions? That's your question? Okay.
Thank you.
Patrick, did you have some questions?
I am good at the moment, thank you.
Okay, Steve?
Yeah, are there a lot of these PRDs in the city? I mean, what are we talking about?
So there's probably 12.5 PRDs, and some of them are bigger than others. There's some that are very small. There's some like, Marblehead is a PRD, and there's a few in there, and that's like 315 units. All in all, there might be like, 2,000 housing units.
Individual units,
Yeah.
okay. And so I think what you said is that the sort of default position is to not, if you don't have any guidelines, to not allow.
Correct.
Okay. So what we're potentially doing tonight is changing that or suggesting some sort of change to that approach?
I'm going to defer to Jonathan here as the city planner to kind of talk about like what we want to do moving forward so that these projects will be easier to review.
Sure. So part of why we have this item as well is some inconsistency historically. So staff at times have said if you have approval from the HOA, then that's sufficient. We won't pay attention to any development standards. At other times have paid more attention to is this consistent with the neighborhood, or is if your entire neighborhood's single story and you're doing a second floor addition, then we may take a look at that through the process that was mentioned before, the amendment to a prior approved project. So there have been a variety of ways that staff have addressed this in the past few decades. The majority of these properties that went through this process were approved in the 70s and 80s. So that's the primary block of time. And since then, there has been change over time. So I think setting an interpretation just sets a more clear standard of here's the norm moving forward, and it's not up to just a person at the counter and whoever you encounter on any given day submitting for a permit. It's going to be something that staff become aware of across the board, that universally this is how you approach a permit that's submitted in one of these neighborhoods, and what their path to approval would look like.
Okay.
Yeah, I think I want to answer your question too, because I want to see, Jonathan, if you agree with this, because this is my understanding of the situation. If I were just to do it in 1 minute, here's the issue. We have permissive code. So the permissive code basically means the city can only approve it if there's established standards. That's what permissive means. You have standards, we can do it. You don't, we can't. That's the problem. So what's the current practice? What does the staff do when an applicant comes in? Well, the staff kind of has an ad hoc process, and they are going to look to see if there is an HOA with guidelines. And if there is, then the staff will look for consistency of those guidelines, like with the character of the neighborhood, the things that John had mentioned. And then they'll do an administerial approval. If there's not an HOA guidelines, essentially, then the staff's going to say, well, this is a significant we have to process this with a public hearing. So it's either going to go to the ZA or it's going to come here. That's essentially what happens when there's nothing. It's just going to rinse and repeat, go to the ZA or come here. And I think what the staff is saying tonight is, okay, that's our current practice. Are there any recommendations that you guys have to help us put in place a process that would alleviate the need to always go to a public hearing? What else could we do? What other options are there? I think is that right? Is that kind of the gist of what you're looking for tonight?
Yes, I think that's a good summary.
Okay. So hopefully that answers your question.
It says,
Cool. Did you have anything else?
not right now.
How about you, Scott?
I do. And I guess, so when an application comes in right now, does staff look at its conformance with like the underlying development standards in the zone, or just because it's a PRD, there kind of aren't any?
Yeah, so let's, Brendan, if you could go back to the image of the neighborhood. Let's go one more back, just as an example here. So the underlying zone is residential low. Residential low has 6-foot side setbacks. In some cases, so at the end of the zoning code, there's an Exhibit A that includes RL-1, RL-2. So those were the standards that were adopted when the PRD was approved. But in some cases, there's a gap of information. So this is an example. The underlying residential low zoning standard has 6-foot side yard setbacks. You can see visually, clearly this doesn't. Most of these buildings are attached. That's not addressed under our code. So already it is non-compliant with the underlying zoning. So then when someone comes in and says, I want to do an expansion, and it'll be within the footprint of the lot, we are in a unique position where already clearly these buildings don't comply with the underlying zone. So it's difficult to enforce that standard. And what we are looking for is, again, yes, consistency in how we allow them to have their requested projects fairly evaluated across the board.
Okay, thanks. On the issue in February, was part of it was that the HOA kind of didn't weigh in on it, right? Like, they wouldn't approve it, but they wouldn't deny it? So we were asked to approve it?
There's no standard.
So in that particular case, the water was a little muddy as to what they approved. They ended up approving something. And then when we were trying to use our discretionary process to evaluate whether that approved project from the HOA side was in character with the community, there was significant public interest. And all of their comments stated, no, this is not in character with the community and it needs to be reevaluated. And on what grounds did the HOA approve this project? And they didn't really have any objective design guidelines in their governing documents that would allow them to do that. So it basically became the responsibility of the city to determine, like, is this in character with the community? If they're going to make an addition, how much is too much? Like, are there additions permitted at all? Like, and this is all outside of the textual code.
Okay. And,
Also, can I just,
sure, please.
but they couldn't actually produce an approval, right? I mean, wasn't that part of it? The HOA didn't actually approve the project. I'm pretty sure, wasn't that the case?
Yeah, let me hop in real quick. So the HOA reviewed a conceptual plan and approved that. But part of where staff's elevation of this came to was a couple of things. One, a code case was initiated for building without permits. And two, there was some deviation between the building version of the plans that were submitted under the building permit as opposed to the copy of the HOA approval. So that was what flagged that one for additional review.
Okay.
And is part of this what we're asked to look at? If an HOA does create standards, let's say they don't have them now, but they want to create their own development standards, that would the city, are you suggesting that the city would review those standards?
That's within the menu of options for the Planning Commission. So the original approval, this neighborhood, again, just as one example, it looks like a condo community. And the typical expectation of a condo community, although it's not, because they have lots, so, but the typical expectation is you can modify your interior, but, you know, the outside of your building, you're not touching. And so the Planning Commission could provide that direction, that we think that there was intention to the design of this community, and they need to go back through a formal process if they want to change that design. That could be one option in your menu. The other could be, we prefer to provide deference to the HOA, and simply what we want is that the HOA, at least within their community, with input from their members, adopts some form of guidelines, and staff, we want you to defer to the guidelines that they adopt. Those are different options within this range of, again, menu items.
Okay, does staff have a suggestion or preference as to which of these options they would like to see adopted?
I would say that the past practice has primarily been between 1 and 2. Those are, we do try to give deference to the HOA. In narrative, we sometimes have challenges with that as well, where one neighbor says the HOA won't approve my plans, but they approve that guy's, and it looks like, you know, and so that issue sometimes does come up in that scenario of only relying on the HOA, where it depends on who's reviewing the plans at any given time. And
Sorry to interrupt, but
Yep.
HOA boards and committees and stuff change over time,
Change
and so
regularly, yep.
what one guy did might not be applicable to the next guy.
And so number 2 would be the case-by-case review, where it simply, does it pass the eye test? Is this consistent generally with the neighborhood? And if it really stands out, a common one that we get now would be everything in the community has, for instance, stucco guardrails, stucco walls, and now someone wants to do glass everything to change the view. And so while we understand that, it does present a significant change from the aesthetic in the neighborhood. And so something of that sort, we might seek out design review and or a public hearing opportunity to determine whether that is an appropriate change and shift in that community.
Okay, thanks. No further questions.
Karen, did you have questions for Brandon or Jonathan?
I do, and I also enjoy the benefit of being at the end here, and getting all the input. So Jonathan, the HOA, it was shared that the HOA should have developed standards, and clearly there was, on the last project, the waters were muddied on that. The process on number 2, if we were going to look at number 2 right now on a case by case, can we now, at this point, reach out to the HOA and say it's time to develop your standards, or is that something the city is able, so that we don't continue to run into this and we give them, let's say, I don't know, 6 months to come up with standards? Do we know who doesn't have standards? I guess that would be the question. And then to amend something, you mentioned, or someone mentioned the administration amendment. Is that something that's always in the back pocket that can happen?
Yes, so, okay, 2 questions. So the first one, I'm going to respond in reverse. So the amendment process is a component of our code. So any prior approved project, whether that's a track map down to a minor architectural review, the applicant or property owner can request a change to that after the original project has been approved or developed. And how the code handles that is it gives the city planner authority to determine whether or not there is, whether or not it's a significant change and whether or not there's public impact or concern. And depending on that matrix, it would either be approved administratively or require a public hearing with the zoning administrator or planning commission. So that would be the process for any requested amendment.
So none of these would change that?
None of these would change that portion of the code.
That was my concern.
Yeah.
Okay, go to the next one.
And then regarding interaction with HOAs, our experience has been mixed. We have a couple that have been responsive to this. I think as of recent, the position under that amendment process has been, I'm happy to approve things administratively. If you can show that you as a community, you had an HOA meeting, you said, here's our proposed guidelines, we're gonna adopt them at our HOA meeting, then my position has been, we'll approve that administratively. I don't think that I could say that there's public impact or concern if your community adopted those standards. However, we have not had regular responsiveness from HOAs on that. So then it kind of falls onto the property owner, the project proponent, to push internally with the HOA to say, I can't move this forward unless you take action on that. Sometimes it does put staff in a challenging position where, in that scenario, where we are the ones holding up them from taking that action. And that may be the appropriate process to continue, but it would be even more beneficial, I think, to say this process has also been reviewed by the Planning Commission, which is a cross-section of your peers and residents here in the city, and they agree that this is what needs to happen. So you do need to push internally. You do need to get your HOA on board.
Okay, thank you.
Just to add to Jonathan's point, I've got a sheet here in front of me that has all of the known PRDs listed on it, and I was able to find robust development standards for 3 of those, and there are 15 more on this list where I was like, I don't have any documented development standards. That doesn't mean they don't
They don't
exist,
exist,
but
they just
they're
haven't
not known to
shared.
me.
Okay, thank you.
That's disappointing.
It is.
I'd like to share that I did discuss this with Jonathan ahead of the meeting, that this feels like kind of a challenge to kind of sort through this. And I thought it would be helpful if I put a lot of thought into maybe how could we move forward tonight? And so I did prepare something, and Tamara, I think you have it, a document. It's a Word document. And I just want to have her put it on the screen, and then I want to walk you guys through it, and then maybe we can use this for discussion. And if you guys, we can just work off of that. Does that make sense? Okay. So if you could just scroll down, keep scrolling, right there. And then I'll tell you when to scroll again.
You want my mouse?
No, that's fine. If you look at it on the screen in front of you, it'll be easier. So let me just step back. The problem, San Clemente has older communities that were established decades ago and have no they have no documented development standards in our records, city records. Some newer ones do, but older ones don't. And the way the municipal code in San Clemente is, it's permissive, meaning in the absence of that, you can't do it. So that creates a problem for residents. There's ambiguity, and they don't, how do they move forward? So it's really the residents at the end of the day that are stuck. So what we need to do, our challenge tonight is how do we help residents move forward when they're in that situation? So here's the framework I want to propose. I want to propose a path where the PRD has an HOA, and then a separate path where there is no HOA in the PRD, and we handle them separately. So that's the notion. So let me just
Can I interrupt you for a
yeah,
second?
yeah.
What about the case where, which category would it fall into, I assume, if there's an HOA, but they don't have development standards? That stays in the first category?
Yep,
Okay, thank you.
yeah.
And do we have PRDs without HOAs? Do they exist?
So we took a look, there's one area that it falls under a PRD that does not have an HOA. However, that area is developed really in a standard single-family configuration. A portion of that track map it has an HOA and a portion does not. So the portion that does not is a standard single-family configuration, and I think we would be comfortable applying the standard underlying zoning in that case.
So, are we good? Yeah. Okay, so for HOAs that do have, for PRDs that do have an HOA, my recommendation is we suggest to staff that they contact them and say, you know, you had 3 that do, cool, and then there's some like 12 that didn't, something like that. We'd contact the 12 and say, with a letter, hey, we're advising you, highly recommending you develop some comprehensive architectural guidelines that are consistent with the city's general plan and the underlying zone for which your PRD occupies. And something that will support the prevailing architecture and character of your community, and ask them to do it, and tell them why it's important and so forth. And give them, you know, a staff person that can be available to kind of guide them, hold their hands on how they can go about doing that. That would be this administrative amendment here that would give them some guidelines on how they could update that. Then if you could scroll to the, Part B here. For PRDs where there is no HOA, and there's that, this, you know, the recommendation here is the staff would use their discretionary review process. They could determine if they want to put it into a public hearing. But there would be some criteria that we would establish tonight for that review. So I'm suggesting some objective criteria that staff could use to do an administrative review. It would include, right here, if you look at number 2, review criteria, first sentence in, A, compatibility with prevailing architectural character, massing, and scale of the immediate surrounding neighborhood. B, impacts to adjacent properties regarding light, air, privacy, and view corridors. C, compliance with the underlying zoning default development standards meaning setbacks, lot coverage, height limits, all that stuff. And then that's what their review process would be. They could, you know, further, you know, if they get engaged, they could encourage them to adopt their own, but if they didn't, they would use these standards and make a call. And would be the discretion of the staff to determine, based on, you know, community impact, feedback letters, whatever, you know, we're going to kick this up to the ZA, which they do in many cases. They'll decide this may be something we don't want to do administratively, so we're going to ask the next review authority up to look at it. But if it's not, if it's pretty straightforward and the staff can apply these evaluation criteria that's clear, they could go ahead and process that. So that's kind of the framework that I wanted to put us in tonight to see if that approach would make sense. And then I have drilled into it if you guys, I want to discuss this, and if you like it, we can move forward to where I've laid it out in a motion that we could adopt that would have all the wording that we needed to give them the direction. But I want to stop and just say, what do you guys think? Karen?
I like it, I just have one question.
Yep.
Since most of the HOAs fall under a civil standard, are we as a city allowed to ask them to develop standards? Is that in our purview?
To suggest that they do it?
Because they are an HOA.
Right. Jonathan, I mean, what are your thoughts? And maybe our attorney could tell us as well, you know, what she thinks.
And before you answer, this is perfect. Were they required to have those design standards when we approved their development in the beginning? Was it a part of their approval packet, so to speak?
Yeah, good questions. I'm going to respond to Commissioner Griffin's question first. The timeline of these approvals being in the 70s and 80s, what we've seen from the staff reports and resolutions don't seem to indicate that. So in some cases, there's a condition indicating that CC&Rs be required, but there's no specifications as to what those would contain. And then as to Commissioner Prescott Leffler's question about can we ask them to do that, I think this framework, and I'll let the Deputy City Attorney overrule me certainly, but I think it makes sense in that it's not an obligation of them, it's an opportunity for the community, for their community members to have a more streamlined review where we can say under our code, we can justify this as not having public impact or concern when we see from your HOA that you've developed those standards. So it seems to be okay with me, and I'll let Jenna comment further if she'd like.
Yeah, I don't think we would have a mechanism to force them to do it, certainly. Tamara, could you scroll back up to A? Just want to double check this. Sorry, this is the first time saying this, so I'm just looking. I don't know if there would be like a more, again, I'm just looking at this for the first time right now. I wouldn't want this to read that, you know, there is an obligation of the HOA to adopt something when I don't think we can require it. And so maybe perhaps when we're looking at, if you are going to adopt this language, something a little, change the language a little bit more to kind of indicate that. But otherwise, that's my feedback.
So suggested guidelines rather than obligation to provide. Typically, you have HOAs and they have their own rules and regulations, and it's a civil matter. But it has, unfortunately, because there lacks guidelines, it blurred the lines, and it showed up on our lap, which we had to push back, because it was really the HOA's purview. But then it came back to us. So this is how we got there. I just want to make sure that we are not doing anything to put us in a situation. I like what you have. I think it's clear. Just want to make sure that it's,
Yeah, instead of require, we can just simply suggest that they do this.
it'd make it easier for us. It's better for the
Yeah.
community. It's more
And
consistency.
to get the streamlined process, if they opt not to or don't do it, then they'll have to go through the more time-consuming, one-off, look, review by staff using the criteria, in which case they may or may not need a public hearing. And if that works for them, cool, but if not, and they want more of a standardized thing, they can,
Yeah.
we have a framework here which they can
Framework.
navigate the city structure to achieve that goal. So this is really just a policy, I think, and I apologize, Jennifer, for not getting this to you. I just gave it to Jonathan late this afternoon, and I wasn't even sure he wanted me to share it. Because if he told me, I don't like this, I just would have not said anything. But I think in our conversation, what you led me to believe is that this would work for you as a policy. You'll live with it for a while, see where the rough edges are, and then when you have a sense of what to do to refine this, you'll come back with an actual zoning update that we could then recommend to the city council that has some of your best practices baked in.
Yeah, to clarify for the commission, the goal would be anytime that an interpretation is issued, that is because there's ambiguity in the code, and so the goal would be to put that into the queue for our zoning cleanups. So when we bring a batch of other zoning amendments to address with ambiguities, we would include this, which would also be another opportunity if the commission or staff recognize in the interim that there's certain hangups, there could be refinements made at that time during a formal amendment process.
Mr. Chairman,
Yes, Commissioner Griffin.
thank you. Without I want to make sure I couch what I'm about to say. I'm not anti-helping the public by any means, but the suggestion here is going to put work on staff. So I want to just make sure everyone understands. And when we say, just send some letters and then work with them, that's a lot. It's a lot of work that's going to be on staff. I also think that these communities likely had an obligation to develop their own design standards. And so the comment of just assign someone to work with them to develop their standards, that's going to be a lot of staff time. And I want to make sure we all recognize that before we just say, let's do this. I'm inclined to be a little more onerous on the HOAs and go with something that just says, this is it, number 4 or number 3 from the staff report. Given all of that, it might be a good thing to let the city attorney's office and let Jonathan and staff bake with what you've brought up. Let them look at this and maybe not take action tonight, and let them come back with kind of a hybrid of what you've suggested and what
And
they've
that's exactly
brought
what
up.
I'm proposing as a hybrid, and I don't think we can get it all sorted out tonight. It's too much. Unless unless, Jonathan, you really want us to try and give you something more concrete. Are you okay bringing it back?
Yeah, no, I'm not suggesting we should kick it down the road, but I'm just a little concerned that we've got your 4 suggestions and then some more suggestions, and.
Mine's a hybrid of all of his
Yeah,
suggestions.
but the words need some wordsmithing, et cetera.
Are we in discussion?
Yeah, we're in discussion, so Commissioner Camp.
Yeah, I think it's up to us if we want to make a decision tonight. First of all, thanks for doing this. It's helpful. But I think that there's definitely some potential issues with this. For instance, HOAs aren't typically set up to do after-the-fact guidelines. I mean, how do you do that, right? You look at what's there.
Yeah.
And you try to set
You talked
some sort of standards. So there's a concern, I think, that in developing, if they want to develop the standards, that number one, they're not going to know how to do it without direction from the city. Number two, it could be politically motivated within the community, in which case it could get out of hand, right? So there should be a mechanism where even if it's the DRSC, can look at guidelines and say, yeah, that's appropriate, for this particular architectural style or this particular development. I think that needs to be,
I like that
part of
idea. It's kind of like addressing what Patrick was talking about. Instead of throwing it on the staff could be a facilitator, and maybe the DRSC has a meeting to.
yeah, and again, it's just to review and provide
Or be
input.
available for a meeting.
And I think that would help staff likely to react, to the kind of guidelines that they get.
Okay?
Yeah, that's certainly a big concern is that they aren't able to do that. Also, there should be CC&Rs with these PRDs, even if there are no design guidelines. And often those address, these kinds of things. It's good, I think, that we saw sort of an extreme case, that was, and I understand that's, I don't know if you guys are aware of what this project was, but they basically just demoed, a big portion of the structure. And we're proposing things that were outside of what had been approved. So that's the big danger right there. And I think we still need to have the opportunity to look at those. But I don't want to, I think that the biggest problem with delaying these things is having to go to planning commission or having to go to the ZA. So, yeah, we're not trying to pile work on these guys, but that's their job,
Yeah.
right? And For us, I think
it comes
we're
to-
it's oversight.
Yeah.
It's just oversight. And even with that one that we saw, I don't think we were prepared to make any major decisions about it, because in that case, they had an HOA. They were already involved.
They even had an architectural review board.
Yeah. And so for us to try to override that, or even, that's assuming a lot of liability potentially, and certainly responsibility, for doing something that we're not really, I don't think we should be necessarily getting involved with. So I'm just throwing out some concerns.
And a suggestion, there are all kinds of consulting firms that do just this type of work. Again, I'm not trying to deflect from staff, but they all have full-time jobs. And in my opinion, these HOAs had an obligation when they got approved to build their stuff. So we could also suggest that here's a list of design firms in the area that can help you navigate the city's zoning code and develop design standards. So just something to think about. I just am very concerned about putting all this work on staff. It's,
Well, yeah, and those firms that do that kind of thing, they cost money, obviously, right? So
right.
that's where it gets a little bit tricky, because you're, in a way, and I guess we're just suggesting that they spend the money to get it done
Yep.
properly. But we have an HOA, my community, and so, you have to get approvals to spend, a certain amount of money to put a full set of the guidelines together.
Yeah,
Could end up being an expensive
I agree.
undertaking. So, and I think, we're not gonna be getting, well, who knows? But we're probably not gonna be getting a lot of these where they wanna make major changes, there's not a lot you can do, especially with the underlying zoning having already been exceeded. So I just think we need to be careful and try to avoid, except in extreme cases, even getting involved in these things, So that's why I like the fact that we have, here's your program on how to deal with these. Only bring it to us if it's very extreme, right? And the homeowners, like in that case, there was a lot of people here that were against, even though it was approved, what this guy was doing, with his property. So I don't know if that helps.
But they handled it,
sorry?
ultimately.
Did they?
I mean, they had a mechanism to go back to the HOA. There was,
Well, they sort of had to, the thing was,
We forced them to, I
Yeah.
think.
yeah.
Because they wanted us to make the decision, and I think we said, no, we declined to make the decision. You need to work it out. I don't know do you have a follow-up, what might have happened on that particular project, Jonathan?
Yeah, given the discrepancy between the building permit plans and the HOA plans, we just required that they get updated approval so that those were coherent. So my understanding is that they submitted and the HOA denied their resubmittal.
Okay. So,
So
he's
did
got,
they button it up, or did they
Yeah,
just
so
still?
is the building official on him
that's a code.
to resolve it?
I don't have an update on that front. I can get an update on that front
I
end.
think we should.
I think it should be extremely heavy-handed
Yeah.
before rainy season,
Yeah.
because what that guy did to those neighbors was criminal. So,
Yeah, Scott, you took a look at it.
it was unbelievable.
Yeah.
So for those that didn't see it, it's a regular building, like, there's 4 units in a row, and the guy demoed his entire unit, including the front wall and the back wall. There was just a A-frame roof over it, and then he exposed the walls of the 2 neighbors. And birds, you could fly a helicopter through there.
Yeah.
Like, it was unbelievable. You've never seen anything like it in a condo building.
Yeah.
So,
You want the
are we
floor,
on this?
Scott?
I do, if
Okay.
that's okay.
Yeah.
I think if we, my first I resonate with a lot of the comments that have already been said. I don't really like the city staff having to kind of hold the hand of all these HOAs. I think if we ask them, we might get 15 different poorly worded standards. They have no idea what they're doing or how to write them. They have no money to hire consultants to do it right. The whole reason I think part of this came to us is because the HOA didn't want to make a decision. And I mean, it could easily be 50 or 100 grand to hire a consultant to make these standards and, you know, that's $1,000 a unit or whatever. They're not going to want to do it. I'm wondering how big of a problem this really is, how frequently it is a problem, and like Steve said, occasionally if it comes to us, okay, you know, we'll deal. But my first reaction, I appreciate you creating what you created. Obviously, I haven't reviewed it or read it. My first reaction is, let's stick with one or two, or a version of one or two, what they're already kind of doing. Because in most cases, it probably works. In most cases, they get an HOA approval, comes to the counter, they approve it, great. And it's not that frequent that it's a problem. I don't, you know, again, I haven't reviewed your thing, Cameron, but some of the things, I definitely don't want to adopt it tonight, because you're talking about, oh, well, we need to be sensitive to privacy and view corridors and this and that, and anybody can claim, oh, well, they moved it out 6 inches, now my privacy is affected, or we don't have view protection standards, so why are we protecting view corridors? Like, there's just a lot there, and I definitely don't want to throw a significant thing in staff's lap, because I just think you'll get all these poorly written things coming back, and then staff's going to be, you know, like, why am I doing this?
I think the issue is not 1 and 2. 1 and 2 is when things kind of are smooth, when there's something in place and the staff can just look at it and say, check, check, check. That's really not the challenge. The challenge is if that doesn't exist, then what do you do? That's really what
And we
need
can
to
say
think
it goes
about.
to ZA, and if ZA doesn't like it, they kick it up to us.
What maybe, listening to Steve talk earlier, maybe that's something the design review subcommittee could deal with rather than the planning commission, and then give a recommendation to the ZA.
So here's my thought on this, if you don't mind me
No,
just jumping in.
please jump in.
'Cause I'm-
That was
I'm-
my thought.
Okay, good, because I've made some notes here. So HOAs still have to adhere to our ordinances and zones, which is design review. So they still have to do that, even if they don't have any guidelines.
Correct.
And I don't think cities can intervene and dictate how an HOA is to establish such zones. That's up to the HOA, because typically, we don't, it's their thing. And their community members are part of that. So until there's an issue that now comes for zoning, buttoning up, code violations, any local ordinances or state, or then that comes to us. But I don't think we go to them and say, you need to do this, this, and this. I think it's in reverse. And it's going to be a one-off. So, like, we just got hit with the one-off.
Right.
Yeah, and I could just add, if I can.
Yeah, Steve.
Jonathan said there was only, I think, one that even complies with the underlying zoning. So I think the more simple, I guess, solution is if you're already exceeding the underlying zoning, regardless, you're not allowed to make significant changes, you know, interior, I mean, they can determine if it's interior, and even, you know, the one that we saw, they were flipping.
They were flipping
They were
the
putting
layout.
the bedrooms on the bottom, I think.
They were.
They're
and-
reversing
and
it,
the-
yeah.
Yeah, social areas on the top. So that wouldn't be allowed. And if there's an HOA guideline, then they can follow that. But if there isn't, they can't make,
It's a
you know,
zoning
they
issue.
can't make these changes.
Yeah, it's
The one that's maybe complying with the underlying zoning guidelines, yeah, you can review that within those guidelines. If it's architectural style, which some of these don't have any real architectural style, if you want to try to pick it, then, you know, that becomes something that you can't change, you know.
So you're kind of leaning into the permissive framework a little bit, saying, hey, if
Yeah,
it's,
you moved into a PRD,
yeah,
you know, and not to be insensitive, but you know that these are all standard. you
Yeah.
know, And, you know, this guy, was, he was kind of a maverick, that's putting it mildly. You have to deal with those, but that's gonna be the rare.
But that's a code violation.
Yeah.
So
Yeah.
just- And city has an obligation, if they're aware of it, to go out and issue a violation if.
So let's review this option 3, because I'm kind of sensing that's what you're, in the absence of clear development standards that allow for additions or alterations to the primary residences or attached accessory structures, planning staff will presume that additions and alterations were not anticipated within the original approval of the PRD. And the intent within that community was to allow maintenance, but not modification to units. In this approach, any expansion of the units, additions to primary residence or their attached accessory structures would not be permitted without amending their PRD standards. These amendments would be applicable to the entire PRD area and would be reviewed by the Planning Commission. That's kind of what you just said, Steve, I think, if I'm listening to you correctly.
Yeah.
And that's kind of what I'm hearing from you, Patrick. And Karen, I think I'm hearing the same from you, that,
As long as it's not required.
right.
Like the HOA standards then comes back and staff says, okay, we approve that. I don't think we can do that.
Yeah. Let me just read option 4, because this is a slight deviation from option 3, where the PRD amendment for an entire PRD area is approved by staff if the proposed standards are reviewed and adopted by the applicable HOA at a properly noticed meeting. However, planning staff could refer proposed amendments to the Planning Commission if staff believed that the proposed standards would not contribute to a cohesive community character.
I've got a question on that.
On number 4?
I'd like to have
Okay.
legal.
So,
look at.
for staff, when you say a properly noticed meeting, do you mean a public hearing by the city or a properly noticed HOA meeting?
The intent was the properly noticed HOA meeting.
And so would we be policing that, so to speak? Show us, that you noticed
So it's
it?
your notice, that's what they would
And-
do, yeah.
Yeah,
Okay.
I think that's again, stepping overreach
Well,
for
I'm-
HOA. That's not in
the
our
part I
purview.
liked about it, though, is that it's giving staff a little more discretion. If the HOA has checked that box, they don't have to check the box, but if they checked it by having a properly noticed meeting, then staff can move forward without it being delayed by coming to us.
I just don't
Versus number 3, they would come to us always.
I still think that because this is a civil matter and cities do not intervene with HOAs, I think we're overreaching. And I could be wrong, but I'd like to go back to have a legal, we have legal.
Yep.
We should look at it, just to make sure. And it would be more of a suggestion and not a staff-approved, standards reviewed, adopted. I think we're getting too involved in HOAs.
Yeah, I hear you, Karen.
I don't like that they don't have standards,
I
but
think Karen, let me just
Opinion.
run this by you. This is, I think number 4 is saying, if the HOA does propose new standards that would apply to the entire site, and they can demonstrate that they did it in a way that was embraced by the community, in other words, they noticed it, and I don't know if that's the way wording, I mean, typically, it's kind of like you have to convene a meeting and a vote, if you want to adopt
that's
something.
up to them.
That's up to them.
We don't get involved in that.
Right, so, but that, if they did, I don't know that we need number 4, because if they do that, now there's development standards, so,
Exactly.
Yeah,
But number
That's true for three
4,
also.
number
Yeah.
4 allows them to not have to come to us. Am I right with that, Jonathan? Versus number 3, it would go through us, which takes time, which is money for them.
I
They shouldn't have to bring if some community goes out and adopts their standards.
Yeah.
Why are we reviewing it at all?
Yeah, we're
That's
not,
right.
we're not involved.
That's right.
It's an HOA, that's their purview.
And
It's
that
not
would be
ours.
number 4.
No, it's number 3.
It's number 3 and strike a couple sentences out of number 3.
Which would you strike, Scott?
I think the last couple.
The last couple, so,
Let's see,
in this approach, starting there?
let's see, in this approach, any expansion of the use, additions would not be permitted without amending the PRD standards. Yeah, I didn't get to strike the last couple. And then if some community goes out and adopts their own PRD standards, then we shouldn't have to be reviewing their PRD standards. It shows up to Jonathan's desk with, hey, I've done this addition and it met the standards, we got our fancy HOA approval letter.
They still have to adhere to zoning and
Let's
state
go.
regulations, they still have to go through all that.
building
So it doesn't usurp any of that.
The HOAs, for the most part, are, like, if you could get an HOA to radically alter their kind of standards, I would be shocked, because there's so much, there's a word for it, but impetus to stay the same, because, like, someone's gonna wanna come in and improve it, and like that guy, he wanted to improve it, improve his view and all that stuff. But then, nobody else wants to feel like all their units are gonna change, or they're gonna be obligated to embrace the change and everything. Most people don't wanna do anything in an HOA. They don't have the money, they're too old, they don't wanna remodel, whatever, so they just want it to stay the same. So I think that's how the momentum is gonna be in these things.
Here's what I recommend. I think what we should do, now that we've had this conversation, I think we're kind of converging. Let's just walk through each of these alternatives and see if we can come to a consensus on whether we're doing a hybrid of these or just picking number 3. So does that resonate with everybody? I'll start reading them. So this is alternatives provided by staff. Number 1, planning staff conduct plan checks for development in the PRD using any available explicit development standards in Appendix A of the zoning code and verify compliance with the structural height limit of the underlying zone. Planning staff will approve additions and/or alterations to structures so long as the applicable HOA has approved the development plans that were submitted by the city. So how do you guys feel about that?
I'm a no.
You don't like that? Okay, why?
Too much city involvement in HOA business.
Okay. All right, let's go down the line. Scott, how do you feel about that?
The last says, planning staff will approve additions or alterations so long as the applicable HOA is approved. So if the HOA approved it, then we're not really gonna look at it, I
Right?
guess.
That's true.
I'm okay with that.
Yeah, I think what number 1, and I'm not going to ask each of you what you think of number 1, but let me restate it, what I think, in my words. Number 1 is saying, staff's just basically going to look at the zoning. Hey, you meet the zoning requirements. Now let me look and see if there's an HOA approval. If there is, we're good.
Yeah, I'm good with that.
And if you don't comply with the underlying zoning, you're a no. If you don't have an HOA approval, you're a no. Jonathan, check me on that. Is that correct?
Yes, one thing I'd highlight, we reference the structural height limit in this case,
yeah.
because we do sometimes get neighborhoods like the one that was shown before, where the HOA has approved,
Yes.
but there is no setback provisions, so I wouldn't say that we're checking for all underlying provisions of the zone. It would mainly be, are they within the property line, and are they under the 25-foot height limit is
Okay.
really the kind of the bare. So number 1 would be the most limited staff review.
Yes.
And deference to HOA, if I was to summarize it.
Okay, it's kind of it's just a cursory review on the basic facts that are available to the staff person on the zone,
Correct.
but nothing at a site level.
Correct.
So like you say, we're not going to look at the setback, we're not going to look at the lot coverage, we're just going to look at the broad brush there. Okay, Steve, I want to go down the line real quick, and then what do you
Yeah, I'm
think on
generally
that?
okay with it, although I think, we don't have to pick just one of these.
No, I just want to go, I'm going to go through all four of them and see where we're at. So,
Yeah, I think
so
that's
far,
the
we're kind of
direction
okay
we're
with one.
I'm going to go back to one that, yes, as long as it is a 30,000-foot view.
Okay,
So,
Patrick, thoughts on one?
Yeah,
You live with it?
I can live with it, but I'm not sure it responds to.
No, we're going to go
Jonathan's
through all four,
concern.
so we're just going to see which ones we can agree to. And Brett, number one, your thoughts?
I'm in agreement with everybody else as far as
Okay.
number one goes.
So we can live with that. Let's just look at number two. City staff determines whether projects meet any existing development standards. So now we're doing a review. And depending on the significance of the proposed changes, we'll use a discretionary approval process to review individual projects on a case-by-case basis when the development plans seem to substantially deviate from the typical architecture or pattern of the development in the community. So now this is a lot more subjective and a lot more work, and the city's taken on a lot more responsibility to make the call. They're looking at a community architecture style and compatibility. And I think, Jonathan, when would this be applied? Would this be applied, can you just
Yeah.
give some color on that?
Yeah, I could give an example. So if someone came in and said, I have a deck and I want to extend that deck, but I'm going to use the same materials, under this guideline, we would approve that over the counter. If they came and said, I want to put sticking with the deck example, I want to put a deck over my garage and have a guardrail all the way around the top of my flat roof garage, and no other garages in the community have that, then that would probably be something that we kick into the inconsistent with the community example.
Okay. How much work, what's the level of effort on the front counter to do that kind of a review?
They would probably,
Is that a Google Earth thing, or is that more like I have to drive out there and look? What is that? level of
either
effort?
or,
Okay.
either of those are acceptable, and then they would review with likely a senior staff person when we have this type of standard where there is some subjectivity to
Okay.
get concurrence.
Okay.
Let me just.
Yeah, please weigh in on thoughts on number two, guys.
So that assumes there's no HOA approval at all. They're just bringing it in and saying, this is what we want to do.
There may be HOA approval, there may not. So HOA approval is always required for permits prior to issuance of the permit. We may or may not have submitted approval at the initial time of staff review.
Okay, because with your example, for instance, if the deck was extended
Yeah.
on the view side, then that could affect the neighbors, right? Their privacy, whatever. So any kind of a change like that, a physical change to the exterior, I think if it doesn't have an HOA approval, needs to be rejected, in which case, I don't think two is it should be part of our.
And my concern with two is the words case by case and the word seem concern me greatly. I think you're going to get pushback from the community that, well, today I got such and such planner and they said blah, 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 and tomorrow it's a different planner who says something else. It's too subjective for staff.
Okay, so I'm kind of seeing us not wanting to support two. Is there changes to two or a prerequisite to two? Like in your case, Steve, if we added with HOA approval, staff determines,
Yeah, I think that would be better. for
okay,
sure.
they come in with HOA.
with HOA approval. So that's a prerequisite. Jonathan, does that add like additional clarity to the process? If we just said number two is okay, but a prerequisite is they have to have the HOA stamp on the plan, approval stamp.
Yes, I would just add, though, I think the delineating piece here is, does the commission think that staff should take a role in evaluating whether changes are consistent with the design of the community.
Okay. That's a great question. Let's,
No,
Karen,
With an HOA, no.
you say no?
No.
Steve?
Yeah, I agree. In which case, you got to get 2 out of there.
Yeah, same with you, and me too. So that's, great, we've reframed the question, we don't like to. Okay, let's do 3. I think I read that one already, right? In the absence of clear development standards that would allow for additions or alterations to primary residences or attached accessory structures, planning staff will presume that additions and alterations are not anticipated within the original approval of the planned residential district, and the intent within that community was to allow maintenance, but not modifications to units.
I think we're again, blurring the lines, and the intent, I think we're being subjective with an HOA again.
Well, this is more like, we're just a no.
Yeah, I think it's.
We're not reviewing it, we're not getting involved, we're just saying no.
Well, okay.
That's what we're saying.
well, I think you could just tack number 3, absence the last couple of sentences, onto the end of number 1. Because number 1 says basically with HOA approval,
Yes.
staff will review it, and then this just adds more information about, hey, otherwise, we're a no. But you
Yeah.
got to take out the last couple sentences of number 3, I think.
So this is the hybrid that I had earlier. I just had it with HOA, without HOA. We're just basically saying, hey, look, you got to have that HOA stamp. So then the framework that I had did have a path if there is no HOA stamp, right? Or they have no HOA, there's no HOA to put a stamp on. Hey, my community does not have an HOA. Now what? That's what, yeah.
Form an HOA. Like, I mean, you bought into it, everyone's consistent, and you want to be inconsistent.
And I thought staff said that every PRD has an HOA.
No, they said they don't necessarily. There's 3 of them, I think, that didn't.
The only area that I was seeing that did not have an HOA was developed in a single family pattern. So there was a PRD applied to the full tract map, but only half of the tract map had an HOA, and the remainder had standard development standards.
What they were referring to earlier, there were 3 that have development standards, and there are 15 that don't. Yeah, not that they don't have an
Yeah.
HOA.
So that's a separate question. So Jonathan, there are PRDs that do not have HOAs.
There's only one.
One
Or there's
section,
one.
It's like a
one
single-family
section,
home.
one
Okay.
section of one PRD.
Okay,
So the vast majority, yes.
okay.
The presumption is they do, yeah.
Now, check me on this, but having sat on design review for a while, if you take some of the projects that come to us, and some of them come because it's an adjacent to historical property, so you'll have a person in a non-historical property, but adjacent to one, and he wants to do a roof addition, an addition, he's got to come before design review. And it's mainly to look at the impact on the historical adjacency. However, I recall on at least 1 or 2, neighbors would come in, because these are all east of the 5 freeway on the coastal side, where there is no HOA over there. There's no HOA along those streets. And I don't know if you remember this, Steve, but neighbors would come and say, yeah, I don't like this guy's addition. And the DRC was in effect the architectural review board for that street. When somebody wanted to make an addition, and literally neighbors came in and were having their say. And we were sitting there in design review trying to referee neighbors' disputes over that, right? So this is the bucket we get into.
Well, but that's our job here. I mean, we'd referee,
Yeah,
huge community disputes. That's our job.
yeah.
So it just so happens, the only reason they get to stand up and say their piece at DRC is because it's next to a historical home.
That's right. Otherwise, it
I mean-
would just be done, or through a regular building permit.
All we're really doing is pushing down the review to the HOA. And the HOA and those community members know the HOA and what's expected there a lot better than we do.
100%. I guess I would just like to, Jonathan, you're going to say something, go ahead.
Yeah, I just wanted to provide a little additional color. So we had a project that came not too long ago that was just a single building. but condos. And it required design review or an entitlement related to exterior modifications to that building. And one of the things that the commission requested through that process was consistency of the guardrails. And because over time, there were different materials on that face. So that might be one that you remember. And,
Yes.
and I think we're in a comparable situation here. And, we just want to be consistent with these communities. And I want to delineate between 1 and 3 that we've just been talking about. So 1 would be HOA stamps the plans, and we don't look into it any further. I don't, the staff doesn't concern themselves with the Google image or the street view or visiting and what type of guardrails are consistent in the community. Number 3 pays more attention to that. And I don't know that we care to take a position on which is the best. I think we're looking for the Planning Commission to say, we think for the community, this is the best option. So number 1 would be heavy deference to the HOA, and staff isn't paying attention to, those elements, the materials, the details for consistency. Number 3 would be looking into that. It would be saying, we, not just that we have an HOA approval, but that there's a level of consistency of the HOA approval that the HOA is relying on. We have these standards and it checked the boxes, and so we approved it. As opposed to number 1, that is simply whoever is tasked with reviewing those has approved it, and that's the end of our review.
Number 1 is within the zone where we have a planning authority, we're just checking to make sure you haven't exceeded our municipal code. Otherwise, the only other check we're doing is that HOA approval.
Correct.
So I think the consensus is that we're good with number 1. The question is, how do we feel about number 3, doing that next level?
Can I interrupt for a
Yeah.
second? I guess I'm not understanding quite what you're saying about number 3.
Yeah.
Because to me, number 3 says, hey, if the HOA doesn't have clear development standards, we're a no to additions or modifications. Not that the staff has to dive any deeper or make any more interpretations. It just says we're a no. What am I misinterpreting there?
No, I think that's correct. But number 1 is ignoring, just does not take into account whether there are any standards. So I was just trying to differentiate those two. That number 1, there's no, staff doesn't concern themselves with, is there a consistent design program for the HOA? It simply is, did the representative from the HOA board stamp on the plans? And that's the only.
Well, I think, okay, let's change number 3 to say, in the absence, instead of clear development standards, that allow for additions or alterations, in the absence of an HOA approval, then we're a no.
We already dealt with that in number 1. So we don't really need
Okay,
number 3.
okay.
Yeah, number 1 requires the HOA approval. My question to you guys is, well, what if there's no HOA? And you guys said, well, there's only going to be 1 community that's the case, which,
They still
Well,
have
they
to-
said there's 1, and it's basically a single-family home neighborhood.
yeah.
And they still have to adhere to the zoning and the,
I guess it would be handled the same way you handle any kind of permit that's east of the that's west, I should say west of the freeway. You handle it just like that. Well, however you handle, I'm not sure how you handle that, but it'd be the west of the freeway situation.
Well, that's all underlying zone stuff.
Yeah, but there's no HOA. There's some HOAs, but there's a large part that there's none.
Would it
Most
make,
of them there isn't.
Yeah.
would it make sense to maybe beef up number 1 so that staff would be looking at things like, oh, that railing in Unit A doesn't match Unit 3, even though the HOA signed off and said, we're good, maybe we beef up number 1 so that we are making sure they're really enforcing
I don't
their
think that's-
standards.
I don't think that's our job.
There's 2 sides to that. Number 1, we're assuming responsibility for checking
Right.
That's
the
a lot.
HOA's work. We don't want to be doing that.
That's too much.
That's what I would call government overreach.
Yeah.
Yeah.
Well, yeah, plus we're assuming liability
Liability, so no.
on that. But number 2, there are no checks and balances on homeowner
I think no.
review which, that's the way it goes.
The
right?
only
I-
time we're going to do that, Patrick, is when the entire HOA comes to the city with a remodel plan for their facade. And then we will look at that.
Right.
But otherwise, individual units, I think we want to do, no. We want to not do that.
So I would like to just throw this out there. I'm okay with one if legal reviews it, and I would not want to approve it tonight without the little note on the bottom, the asterisk, that it goes before legal, just so we know that we are not getting involved in a civil matter that we shouldn't be involved in.
Well, has legal already reviewed it?
I'll chime in real quick and then Jenna can add. So number one's consistent with the city's existing municipal code. So outside of zoning, Title 15 is our building code section. And we do already require provision of HOA approval if there is an HOA. And that's for any building permit that gets submitted. So one would be consistent with current practice.
I think my sense of the commission is we're all on number one and maintaining that practice. And
And my question to staff is, will this resolve your problem? If,
Yes, in that it provides consistency of direction if you were to select number one.
thank you.
yeah. Are there any other areas of ambiguity, Jonathan, that you want us to discuss? Like, for example, where there is no HOA, what's the process there? Is that back to staff doing a discretionary review, or what are they going to do?
Yeah, no, if there is no HOA, then we would apply the underlying zoning, but HOA approval's not required in those cases. From,
No design review, just,
correct, I
Yeah.
don't think that would be necessary in that situation.
yeah. Is there any scenario where Brandon, are we covering everything you need covered tonight?
As long as you provide direction on how we're going to review these projects, so that way we can say with confidence how we handle this,
Yeah,
that will
number
cover our
one.
bases.
Number one. I think is that what I'm seeing from everybody?
Yep.
Is everybody number one? And we don't need to add with HOA approval, right? Because that's already baked into the code. So Jonathan, if we just adopted alternative one, is that the direction you need?
That works for me.
Okay, and then if it turns out over time you need something else, just come back, right? Okay. Let me just look at, so from a staff recommendation, you want us to adopt the resolution, and then in section 2, we'll just insert number 1?
Correct.
Okay. I did notice some dates on here, in the whereas clauses, July 16th, I think you mean August 6th, right? So, and then what about this June 18th, is that also August 6th?
This has been pushed down the road a few times, so I
Yeah.
apologize for not updating
It's just
the
a little
document
cleanup,
accordingly.
okay. So, Jonathan, what you're looking for is just adoption of the resolution with option 1 inserted in section 2?
Correct.
Okay. You guys mind if I just make that motion and we'll go forward? Okay, so there is no CEQA finding, right?
Correct.
Okay, I will move Planning Commission Resolution PC 25-009, a resolution of the Planning Commission of the City of San Clemente interpreting 25-233, the planned residential districts, to provide direction on how city staff should review development in planned residential districts, and finding that this action is not defined as a project under the California Environmental Quality Act. And as part of my motion, we push or insert option 1 into section 2, and we just update the dates on here, January 16th to August 6th, and June 18th to August 6th.
I'll second that.
Okay, so I've made the motion, Commissioner Camp has seconded it. Is there any further discussion on this? All right, let's go for a vote. We'll just do all in favor, say aye. Aye. Opposed? Passes unanimous. Hey, you got your first planning decision resolution under your belt. Congratulations. Okay. we are concluding our new business and moving to old business, which there is none. Item 11 for our new commissioners is a standing item where if, on item A, if there's something that you guys want to bring up, you would do it here. Also, Jonathan will give us a report on things that are top of mind for him. And then this is an opportunity if anyone wants to review we call it the TFA, but the tentative future agenda about, what's on, that's in the packet, by the way. Also, again, for our new commissioners, we are the appeal group for the zoning administrator decisions. Those are in our packet. So this would be the opportunity, if you see a zoning administrator decision that you want to ask questions about, you would do it under this section. Does any commissioner have any reports they want to make at this time? Okay. Do you have something, Steve?
I wanted to make a comment about that letter we received from Larry. Should I do that now, or?
Yes. Now, you know what? Could you hold that? I want Jonathan to make his update because he's going to speak to it.
That's fine.
Jonathan, we're going to go and put his on hold, and he may or may not want to make it after you make your update.
Sure.
Okay.
Yeah, I'll provide a quick update on that. Tamara, if you could grab, there's a link to a folder, 8625, that will take you to some photos. It should be labeled Miramar 8625. Okay, give me 1 second to take a look over her shoulder and make sure we get the right thing open.
Okay. How's the view, Rick? How we doing?
There's a lot of noise back here from all the other spectators.
Yeah, it's hard to hear, isn't it?
Yeah, exactly.
Yeah, for the two people watching at home, we have Councilmember Rick Loeffler in the audience auditing the Planning Commission tonight. It's an honor to have the council member here tonight with us.
So one project that is always of community interest is the Miramar Theater and Bowling Alley project down at North Beach. And so I have a few photos from today, actually, that I just wanted to share with the commission and can respond to any questions. This is a photo on the bowling alley side. This is in the basement area, the shared restrooms. So that's actually the sink and the backsplash wall of tile. And this will serve the various small kitchens. There's about a dozen of those alongside the primary tenant will operate the bar operations at this facility. And you can toggle to the next one, Tamara, as soon as you're ready. This is the exterior of the theater building. There's still some final finishes that will be done here. They were just working with their mason on the interior. They found a brick replica that will go on the interior portion there. And this was originally just a roofed structure with those three columns. The French doors were added as a component of the 2017 approval. Continue on, please. Let's go one more. Back to the bowling alley side, this is the location closest to Avenida Pico, and in the foreground is the limited amount of salvageable bowling alley floor that was able to be recovered. And so it is in that kind of prominent first entry location at this bar. And then you see that there's a roll-up window, so out that direction you'll have a view of Ole Hansen Beach Club in the background. We'll continue on. This is the entire bowling alley area, which again is the food hall. It's actually more finished than it appears. So the floor is finished, counters are finished, but they're protected. So it looks less finished than it actually is. And then we, just acknowledging one change that was made previously, we had an amendment that discussed allowing for some venting material on the El Camino Real side of the roof doing that allowed for this open skylight and open roofing on the interior. So now we can kind of see the finished product there. And the venting on the roof will be painted to match the roof color before the end of the project. We can continue on. This is from today. This is the interior of the theater space. And so you can see that the new plaster has been applied, the lights are turned on, and we have replicas. So there were no surviving light fixtures. There were pieces of them all in the building, but having been vacant for 30 years, none of them were in repairable, salvageable condition. But there was enough extant material that they were able to get them replicated. Most of the replication occurred in Mexico, actually. We'll continue on. Let's keep going. And one more. This is just a zoom in of the replica, of the chandelier element that was in the exterior covered roof portico. Obviously, this being a theater originally, there was not a whole lot of overhead lighting, so these were not original to the space, but compatible with now the use that will be needing more lighting in the interior. We'll continue on. Just a zoom up of the detail of that pendant light. Continue on. And so this is on either side of the stage area. We have these arches. You may have heard a couple terms used for these, Moorish or Gothic. Moorish is more related to the pointed style and dimensions of the arch. The term Gothic is more related to the honed wood bars at the top of that arch. So these are original. The plaster is not original, but the honed wood bars and the location and the dimensions are all original to the building. And the woodwork above is also original, simply repaired, painted. We'll continue on. Just a close-up of that element. And from the outside looking in. Okay. So there, yeah, I'll leave it there. And then if Steve wants to provide his comments, I'm happy to interact as needed.
Okay. Yeah, the letter from Larry Culbertson implied that, there were significant changes. And really, I think, was a little misleading in suggesting that, this is going to be a theater, I think, was sort of the direction. Also, that there was another statement in there that the design review subcommittee just kind of said, yeah, that's fine, everything's fine, which we didn't actually. We had a disagreement between the two, I don't know about the three of us, but between the members of the design review subcommittee. And I was leaning towards protecting the view of the marquee because of the uniqueness of that being rotated 45 degrees or whatever.
Can you go back to that? Did you close it?
To the front view of the
Just go, yeah, we'll tell you to stop. Just go back. Keep going back.
It's one of the first,
Right there.
yeah.
Yeah.
So, there's a couple issues there. Number one is the use of that space. It's no longer going to be a theater. That's disappointing to us as residents of San Clemente and as members of the Design Review Subcommittee and Planning Commission. But a project, in order for this to be improved, there has to be a development of a project that pencils. A theater does not pencil in this location. So our goal, beyond that, is to try to preserve the exterior character of the building as much as possible. And so that's why we disagreed, because they were proposing a new enclosure with a fountain feature that would block the view of this element. And I felt like even though it's no longer a theater, it's still an important feature of the building. And so, we gave them our input, which is what we always do. And it was sort of up to the applicant and I guess,
And the staff.
and staff. And
There was. can I
Cameron
just-
actually, well, I think Jonathan could probably update us on, have they decided definitively on a direction with that?
Yeah, so following that meeting, following that meeting, we met on site with the applicant's design team, as well as the city assistant engineer. And there's going to be another element of this. It was referenced in design review, but we didn't have full details yet at that time. So behind the perspective of this photo, there are vehicles that will have to stop at a stop sign and then turn right onto El Camino Real. And they'll need to look over their left shoulder, this view, and be able to safely see oncoming traffic and turn right. And so the next step for the applicant, they have shared what they want, but now they're going to have to overlay onto the plan the county safe line of sight standard. And that might change what they had presented. And so we don't have yet from them an update that plots that safe line of sight. And so once we do, then we'll be able to take the next step. What that next step would look like is, we went beyond what's required. We did a courtesy notice for that design review meeting. Design review doesn't require noticing, but we did do a courtesy notice for that meeting, in part to gauge what is the level of public impact or concern, since this is an amendment, coming back to what we had talked about before, that code provision that sets up the process of whether that approval would be administrative or go to a public hearing. So when we get the final documents, I'll make that decision as to whether it would be approved administratively or go to a public hearing. If it is approved administratively, notice would still be provided to any of those members of the public who are interested, at which time they would have the option to appeal it to the Planning Commission. Again, if that is approved administratively, that would be their next administrative path to pursue. So given that also, I think that what Steve said is an accurate representation of what will be in the design review minutes. I would say that if you, Cameron could comment on that as well, and Scott, as just a recollection of what happened in design review, but I don't think that anyone else should comment in case this is appealed. So we don't want to get into discussion just in that eventuality.
Yeah, no, I thought this is good. Thanks for bringing that up. I just want to clarify that at the council meeting last night, public comments were made that design review made a decision. And I understand that what we do isn't easy to understand. Sometimes we get confused ourselves, but the reality is we didn't make a decision there. We never make decisions in design review. We're only an advisory body only. We just give recommendations. And in many cases, we're making them to the Planning Commission. In other cases, we're just making them to Jonathan. And in this case, that's what we did. We gave him a range of opinions that said, yeah, we want this function, we want this to have the function for the tenant, but at the same time, we do want to respect the building. So staff, if you can work back and forth with the tenant and come up with something that you feel comfortable, great. And if not, bring it to a public hearing. But I think for me to be clear as possible, no decisions have been made. No decisions were made at design review, and there's nothing to appeal because there were members of the public urging the council to appeal that. Well, there's nothing decided. There's nothing to appeal. No decision's been made yet. So that's the clarification I wanted to put in there.
Hey, Cam, coming to a point of order, taking things out of order, could I use just about 30 seconds of a public comment?
Come on up.
Yeah, I got here a little bit late, so.
Yeah, no, come on up.
I just wanted to make, Steve, by the way, I totally echo your sentiment. That would have been a jewel if that was a theater, music venue or something, would have been great for the city. And we've been looking to put something like that in. We just can't make it work. So, yeah, I agree. Another wedding venue, maybe, but theater would have been a great idea. And then I just also want some clarification. You made a point because a lot of people have been talking about keeping the historical value of the building, and I think you've done a really good job of doing that for what you had to work with. And Verify, so they used original, I assume it was oak that was on the floor of the bowling alley. They use that for actually the top of the bar top that the vendor is going to use in the food court.
Yes, that's correct.
That's awesome. And, you know, I know that you really tried. I went on a tour with you, and we looked at some of the fixtures, and it's like, can you save these? And the contractor's going, yeah, you know, I mean, as they're falling off, and the corbels and all the wood stuff, I think they've done a really nice job of what they had to work with to at least, you know, keep the tenure of that building. So anyway, I appreciate all your hard work. It's good news about the bar top. It seems like a little thing, but I think it's a big thing, really, when you can use original materials. So I've got to go run and unplug my truck. So thank you very much for all of your hard work, and we'll see you soon.
Well, thank you for sitting through that long discussion, Councilmember Loeffler.
would like to know how the sausage is made.
Yep. You saw the sausage being made tonight, and it's really not that exciting. But I hope we get to a good quality product, right? At the end of the day, we get to something very quality. Okay. And is there any other discussion further on this?
Not on this topic, but
Okay.
I do have another separate from that.
Yeah, and we're good? Can we close this off? Okay, Jonathan, next topic.
So I just wanted to rewind to just upcoming schedule. And the first would be a reminder, and I think some of you have all of you have received correspondence from the city clerk's office, but just a reminder that the state mandated ethics training is going to be August 18th. So if you haven't replied or RSVP'd for that, the strong recommendation is to do that in person. If you're unable to, there will be an option to do that virtually. Do you know? 3 o'clock, okay. Yes.
Yeah, my understanding was that we only RSVP'd if we couldn't make it. That's the way
I wasn't copied on that email. If you followed the directions on the email, then you're set. Just here to remind of the date, August 18th.
Just show up.
There you go. And then for the TFA, the tentative future agenda, we tonight was all theory and legislation, and next time will be very heavily project-based. So we provided notice for two pretty significant projects at the next meeting. One will be for a hotel at North Beach that's referred to as the Hanson Hotel. The other will be for the 20 acres of undeveloped area here in the business park. And that project is being called the Luminar Business Park. So pretty substantial projects that will be on your next agenda. We're going to try to get those published a little bit earlier, but maybe something just to keep in mind to save a little bit of time the following weekend to review those packets. Yeah, interesting and complex, but I think we're ready to dive into some good projects at the next meeting.
I would just echo Steve and I have seen both, I don't know if you know, Scott, but we've seen both those projects in design review, and they're substantial in scale and complexity. They're major projects in the community, so please allocate a lot of time to go through all that material ahead of time. Yeah. And don't hesitate, and do it as early as you can, because if you have questions of staff that you want to ask before the meeting, that would be, you know, that's why don't wait till the day of to read it, because you might have questions.
And that's it. I have no further reports. Thank
Okay.
you, Chair.
Does anyone else want to make a comment before we adjourn? All right, I will move that we adjourn to the next regular meeting of the Planning Commission to be scheduled, that is scheduled for Wednesday, August 20th, 2025. Are we doing it at 6?
Yes, sir.
At 6 p.m., and will be held at the San Clemente City Hall Council Chambers. Can I get a second?
I'll second that.
Seconded from Commissioner Camp. All those in favor? Aye. We are adjourned. Good night.